No, it can't be taken up like that. You give the number.
No.
You give the number. But next week, I look on the part.
The part third method.
প্রথমত এইটো চাই লওক এইটো কি ফিক্স আছে আমি চাই লওক যদি আজি ফিক্স আছিলে তেতিয়াহ'লে নেক্সট উইকত এটা এইটো ঠিক হ'ব See, if the date is fixed in the order and it is not listed, we'll list it next week and then see if we can take it up. Otherwise, it goes to October. October. All right?
Automatic listing will be.
The court master will verify.
May it please, my lord, I beg to mention item 24, 25, 26 of today's daily list, my lord. My lord, I seek adjournment for the day, my lord. I am for the respondent APDCL. The conducting counsel, Mr. SP Sharma, is unwell, my lord.
Who's for the petitioner?
I am for the petitioner, my lord. I have for the urgency, my lord. I am for the petitioner, my lord. I have for the urgency.
All right, then we'll take it up. We'll take it up.
My lord, but I have taken consent.
He is not given consent.
The consent, my lord, he may take my lord, on 10th of October, my lord, it means
We asked you, you said you have urgency.
urgency, my lord, 10th of
If
October.
there is urgency, no consent. If you are giving consent, leave the fixing of date to the court. At joint request, matters be listed. All right, on 10th.
Obliged.
Highly obliged, my lord.
If legal lordship, I will to mention item number 20. Really personally.
20, yes.
Leading advocate, Mr. You can add, is out of his station. Your lordship may kindly adjourn the matter for the day.
Item 20 adjourned for a week at the request of Mr. Swenson.
Next,
The arguing counsel is not available. Yes. Yes, yes.
May it please your lordship, item 13 and 14, Mr. Nair has had to go out of urgently, so next week, lordship.
They have
next
not
week is
completed.
available.
I think one petitioner is left to be completed.
I'm ready, my lord.
One petitioner is still left.
Yes, lordship. Mr. Goswami.
Yeah, I think so.
Mr. Goswami gave his consent in the morning. I'll have to give him a call then.
Yes.
Then we have to leave, we'll have to release from Pattern.
I was only informed in the morning, my lord. There was
I
some
also-
prepared with the matter.
I was also informed in the morning he is not in town, lordship.
No, he's not in town is all right, but these are Pattern matters.
Yes, lordship, and when he said next week, any day.
No,
He's
next
available.
week, the docket is full, it's more than full.
Yes, lordship.
So it goes to October, then October it will be to rehearing the matter. Better to release it from Pattern. Let it come before appropriate bench, whoever is taking up these.
So leave that to your lordship, but the lordship has substantially heard the matter.
That's right, but there's no point hearing and keeping the matter.
Lordship,
Without-
one last chance for next week.
No, next
hope
week is
to
not
complete
possible.
it, lordship.
Possible next week. Next week is not possible. There are already matters fixed. This is a hearing matter. It will take some
Yes,
time.
lordship.
And at least you could have completed your argument, so we could have.
Lordship takes it up, I'm ready for
Kaushik is
the.
coming on account, no? Kaushik is coming. He's here. So,
5 তারিখে হবে নাকি?
Lordship, if not next week.
5th October, all right.
Lordship, I'm appearing on behalf of Mr. K. Goswami, item 14. 5th, we have a little difficult. For 5th, we have a little difficulty.
Sorry,
For 5th of October, we have a little difficulty, your lordship.
I have not been able to. 5th is,
He's saying
Fifth,
his senior has some difficulty.
Senior has some difficulty.
we can't help it. Then you
Lordship,
call him today, let us hear the matter.
Lordship, any other date except.
No, this is a Pattern matter.
Yes.
What are you doing? We are closing the hearing. If you have difficulty, we are keeping it on 5th. 5th October. In view of the submissions made by the learned counsel for the respondent that the arguing counsel is out of station. Further adjournments will not be entertained as it is a Pattern matter.
obliged, lordship.
I beg to mention item number 217, 18 and 23. R. Mohinder is out of station and I have taken consent from the other. 217, 18 and 23.
All the matters. You don't want to do not even a single matter. Why?
Lordship, R. Mohinder is out of station.
He's out of station. You are there. You do it.
217, 18 and 23.
The 26 is connected. 23. All right. Yes, adjourn.
Lordship, I beg to mention item 16 of today's daily list, Lordship. This man is going to retire on 38th, Lordship, but my senior, he has got some difficulty today, Lordship. So if it can be taken up in the next week, Lordship.
No, next week not possible. It goes to October.
But the issue is a small one, Lordship.
You argue, we'll hear you. You are available, you argue the matter, we'll hear you.
But my senior wants to.
The
argue.
senior wants to argue, is not here. We can't accommodate him next week. The dockets are full. Please try to understand that.
I understand, Lordship.
If there is urgency, no adjournment. If it is an adjournment, it goes into the cycle of 2 weeks at least. You make up your mind, tell us. You want to argue, we'll hear you.
No, Lordship, my senior will argue.
16 at the request of Mr. MP Sharma, matter stands adjourned for 2 weeks.
Item 16, I am applying for Resolution 1 and 2. Our name is not reflected in the causes. SC revenue.
It is submitted by Mr.
Yes, Doctor.
S. Doctor that Council for Revenues appears in the matter, but their names are not reflected in the cause list. Accordingly, the registry is directed to reflect the names of the cause list.
Lordship,
Names of the standing Council for Revenue in the cause list.
Lordship, in the next week, even if it comes in the end of the list, Lordship, I'll try once, Lordship.
No,
because
you
he-
can't try because the dockets are full. Please understand that. You can't try.
He is retiring. this
He's
month.
retiring, you are taking an adjournment. You should not take an adjournment.
Only because my senior is.
Your senior is not there, so can't help you. Please understand that. We are ready to take up the matter today.
Let it reach then.
All right,
May I
item
please-
16.
may I please,
Yes.
Your Lordship? Your Lordship, I beg to mention item 21 of daily list. Your Lordship, due to some difficulties, my senior.
Item 21, list after 3 weeks.
Negligible. Okay. In this matter, in the last occasion, responding directed to submit some marks from the.
Yes,
Yes, I have received the instructions, Lordship. Petitioner is in serial number 5, Lordship.
what happened? Why no marks?
He has in general category.
Not qualified.
No, he is not qualified, Lordship.
Why?
Because the cutoff mark is 76. He has got 53. So for this second phase, that is oral interview, he was not qualified for phase 2 examination.
What is his?
The other
event?
candidature, number
selected.
1 is OBC candidate.
Hmm.
He is professionally qualified. Number 2 is also qualified for second phase.
But they're not selected.
They are selected, Lordship.
Huh?
6 and 7, they are not appeared.
No, 1, 2, 3, 4 are not selected.
They are selected, Lordship.
Selected? On your phase 2, you write not selected.
Not selected, Lordship.
What are you submitting, madam? Are they selected or not selected?
Here it is phase 2, they are not selected.
Hmm?
But marks obtained, they are all,
No, tell me whether they're selected or not selected. You have not looked into your instructions.
Lordship may take it after some time.
What
I
is
will
this,
call
madam?
Mr. DP Bora, Lordship. After some time. He is in court number 1, Lord.
Yes, DP Bora. After some time. Who is adjourned? Yes. Yes.
May it please, your lordship. My lord, on the last occasion, we started the hearing.
Did we proceed with the hearing?
Means, when I was thinking, my lord, 2015 matter, this person was removed from his service in 2014. We are in 23, and in February, this person otherwise would have retired from service. So either way, my lord, I think we should conclude this matter, my lord. But subject to your lordship's convenience, but your lordship has only to look into the record. I think it will not take much time. Just has to look into the record at some of the pages that whether the exhibits which are referred in the inquiry report,
No, refresh our memory. Tell us
Yes.
what happened. Yes.
your lordship will first look into the petitioner was serving as a senior manager of, at the general office of a UCO Bank and at GS Road, Guwahati. Sorry, Allahabad Bank, then Allahabad Bank at Guwahati. My lord, during his service, my lord, a charge sheet was submitted on 13/6/2013, citing my lord 130 instances of loans, which they say that it is not in accordance with their policy. But all of those loans have been repaid and there was nothing due against those loans. And they say that in some of the cases, there were non-compliance with KFC. In some of the cases, they say that discrepancies in the signature of the borrowers and guarantors. And all these loans were delivered against car loans. And it was, they say that the documents, etc., were not included in the loan. Although they have come into a figure of 1.8 crore loss, but practically this is that no financial or pecuniary loss has been caused to the bank. Now, on the last occasion, your lordship had looked into the inquiry report. That is that your lordship will find in the affidavit in opposition filed on behalf of the bank at page number 7. This is running page will be 111. Your lordship got it, 111. And annexure 3, internal page of the affidavit is at page 70.
Yes.
Now your lordship will see that this is, they have given that 111, the recital of the case, charge sheet, order of inquiry, gist of allegations. Then your lordship will see the inquiry at next page 18, the inquiry. Then they have given the defense documents and all. They have given 2 dates, serial number 3 in the inquiry, 24/1/2014, 25/1/2000. Where we paused at the last hearing was that your lordship had noted that in 6, evidence vis-a-vis allegations and analysis of evidence, my lord, at page 112. Now at serial number 6, your lordship has said, on having PO's written brief received on 15/2/2014, undersigned EO submit now his report findings on the inquiry proceeding. He has simply quoted the documents without discussing any of the contents or the evidence in therein. And your lordship will find in the next page also, he have just quoted the exhibits. No discussion, nothing. Then this continued up to, my lord.
Yes.
up to 115.
Yes.
Then at page 116, that is internal page 22, you'll also will find the heading cross-examination. But cross-examination of whom, my lord? Defense Secretary tells about the reporting of sanction loan as so-and-so, so-and-so. You'll also got it page 116. See, internal page will be 22 of their affidavit.
Yes.
Now you'll also see cross-examination.
Please read.
The cross-examination, defense examination, so-and-so tells about reporting of sanction loan accounts to the general office during the period of so-and-so, but it does not mean that the said loan accounts have been duly sanctioned, authorized by the sanctioning authority of the branch that is chief manager. Moreover, MDA statements are not corroborated in the supporting document. Nothing. Whose cross-examination is this, madam? CEO cannot adjourn it from so-and-so. Then he comes directly to the conclusion at bottom of third paragraph. On perusal of the CEO's reply, it appears that he attempts to submit a cock and bull story without going to the points that is the charge frame. And therefore, the charge frame against so-and-so.
But you know the law
Yes, ma'am.
that there has to be some evidence.
Yes.
That is sufficient.
No, but where is the discussion on the evidence? Where is the appreciation of that evidence, madam?
No, it cannot be
Ah.
by a strict
No.
measure
But
as ordinarily done in a civil or a criminal.
no, here we'll go by the doctrine of preponderance of probability. But the minimum that is contemplated by the Supreme Court will place those judgments. The minimum that is required to prove the contents of a document or how it has to be looked into has been elaborated in several judgments of the Honorable Supreme Court. I'll just
No, but you have indicated these lapses and
yes.
things as a manner of inadvertently,
No,
etc. But these are your replies.
Madam, there is one more aspect, madam. These are the just now your lawsuit. It is a court question. No, what is a funding to the question? Page number 2. Now your lawsuit will kindly see page 64. Annexure 3, our writ petition, madam.
Hmm.
This was, we had given this against the findings of the EO at page 63. Well, these are the point wise. Now, when they filed the affidavit, my lord, they say that we have not replied to the that we have not responded to it.
What is 1 minute.
Now, your lordship, after page 65, your lordship will kindly see the impugn order at page.
111
Yes, madam.
and 63. What are these?
My lord, page, your lordship will first see
111 is the report and finding.
reported finding.
Inquiry report.
Against that reported finding, we gave this page 65.
63. What is 63?
63. Replied to the findings in the,
To the disciplinary authority.
yes, inquiry officer's finding, my lord.
In respect of the promotions.
Now, in respect of
Sorry,
the
in
charge sheet.
punishment.
Charge sheet.
No. This is your reply in respect of the charge sheet.
Charge sheet. Now, your lordship will see page 66, why I was referring to page 63. Your lordship will see,
No,
Base-
but the kindly see the subject. It says findings of EO
Ah.
at page 63.
yes, ma'am. Findings of the EO in the department and inquiry held in respect of the charge sheet number so and so.
So this is pursuant to the inquiry
Yes.
report.
Yes.
This is filed to whom?
This was filed to the general manager and disciplinary authority of the Allahabad Bank.
So this is pursuant to the subsequent perhaps show cause for imposition of punishment after acceptance of inquiry report.
No. After the finding of the inquiry. officer.
After submission of inquiry report.
Yes.
Copy was served on you.
Yes, and we replied to it. And what was the response your lordship will find at page 66? So that was the reason why I was referring at page 66.
Hmm.
Your lordship got page 66?
Yes.
Now your lordship will see first, second, third, fourth, fifth. I have also gone to the representation of the charge officer on the findings of the inquiry officer submitted by his letter dated 2/5/2014, page 63, my lord.
This is whose reply?
This is my reply at page 63, which I have just referred, my lord.
No, page 63 is a portion of the, is a letter or order of whom? The disciplinary authority,
Yes,
referring to your reply.
yes. ma'am. This is at page 64. It starts at page 64.
Hmm.
It starts at page 64 and the relevant portion is at page 66.
Hmm.
You'll also got it page 64. You'll also will see the heading.
Yes.
64 is the heading and the relevant page is at page 66.
Yes.
I'm just pointing out some of the lapses, but because I may have so many grounds, but let us be pinpoint and specific on the grounds on which you are challenging this. Page 66, you also will look at the 5th paragraph. I have also gone through the representation of the charge officer on the findings of the inquiry officer submitted by his letter dated 2/5/2014, that is page 63, wherein it is observed that he did not submit point-wise specific reply of the charges level against him. He attempted to submit a cock and bull story without going to the points that is the charge framed against him. So against this, my lord, that the page 6.
Yes.
Now, when we look into the record and into the record, we find that at page number 170, the response is there.
Hmm?
Point-wise response. He says that point-wise response was not there in regards to the findings of the EU. My lord, that is your lordship, if your lordship looks into their inquiry, page 172, right? Inquiry
170.
170.
What were your allegations in the first place?
Allegation, your lordship will see the charge sheet at page 16. One second. 170. The first allegation is, my lord, loan disbursement success, non-compliance with KYC norms. That I have not complied with the KYC norm. The second is discrepancies in the signatures of the borrowers and the guarantors, and allowing car loans where cars were delivered by the dealers to the borrowers prior to sanctioning of the loans, and non-retention of documents like sale certificate, registration certificate, invoice, etc. So the 170 mark. Out of file, sir. Out of file, black mark. It will be.
So it's basically car loans.
Car loan.
All of them are car loans.
All of them are car loans and all of them have paid. There is no default in payment of the car loans. All have been repaid back. And this point-wise reply I have given to the charges who actually the fading memory was that I did not recollect that this was submitted, but in the from the record we find that this is there.
These are the articles of charge.
Yes, ma'am. Then against each of these charges, reply is this.
No,
one.
what is the charge?
Charge your lordship will find. Statement of the article of charge at page 19. They have elaborated as many as 130 up to page number, just a moment. They have up to page 60. The charge from page 19 up to page 60 is the article of charges framed against the petitioner. Then the list of documents by which the article of charges were to be proved are at page 61. although they have stated 3, but this serial number 3 includes documents, papers mentioned, stroke related to the charge sheet are held in the Panbajar branch documents of respective accounts. And witnesses, one at that by which it was to be proved is the is the manager of the Panbajar branch. Now, at page 63 was the findings of the, this was in page 63 was the against the findings of the EO in the departmental inquiry. This is my lord. Then at page 64 is the decision of the disciplinary authority. This is your lordship will take note that page 64 date
Where is your reply?
again, page 64 is the reply I have just shown it to your lordship from the
Hmm.
record, my lord.
No,
Page
page,
72 of the records.
no, page 64 is the decision of the disciplinary. order.
Yes, and in the page 66,
No, where is your reply to the charges?
my lord, it's in the record, my lord.
Not here.
Not in, I could not get it annexed.
Why?
Only when I looked into the record, I find that this was the memory fades, my lord. I was terminated in 2013, 2014. I filed this petition in 2015. Mental balance was not there. I could not recollect that this.
No,
but in
that
the
is
record-
okay. Mental balance, forgetful, everything, I agree. But your basis of your defense
Yes, ma'am.
has to be on the reply that you
Like,
furnished.
No, what I was trying to
If you're,
show-
if you're
yes.
not, if this is not one of your pleaded
No,
grounds.
my lord, we have pleaded all the grounds, my lord. But,
Mr.
but your lordship
Kaur,
will
Mr.
see.
Kaur,
Yes,
Mr. Kaur, this is an elaborate charge sheet,
yes,
giving reasons, what are the charges against
Yes.
each particular
yes.
person. There are different documents which according to them, you were required to maintain in the record, which was not done.
Yes, ma'am.
Now, against that, you said you have submitted the reply which is available there, but not here.
Not here because, my lord, we had the copy, but we are not sure whether this was because the person, when we asked, unless we have a specific instruction that
You
this was.
bring it on
submitted-
record. You bring it on record.
My lord, we had brought it on record at page 72, but this dates and were not there. It's not that we have not given, we had given it at page 72. But we find the date and all because it is in the record, my lord. Annexure 7 at page 72 is the same one which we have there in the record.
What are you submitting? Once you say the
No,
reply is not here. This is an appeal.
No. This is the document where this is against the statement which they have referred at page 66 that I have not replied to the specific charges. And this is prior to 2 months of the order, prior to 2 months of the disciplinary authority's order. That's how it is. এখন কোনটা কি আছে? Page 72 is dated 21/3/2014. That's why it was because the date was not there in the copy furnished to us, my lord. That's why we could not take that specific above, my lord. But we had annexed the
All right, then.
now your lordship has seen that against each of the charges I have submitted. But whereas at page 66, they say that I have not submitted against specific charges. Page 66.
Hmm.
Yes, the serial number 1.
No, what is the meaning of
Meaning of my lord?
This is a standard account. What is the meaning of that?
We are checking it. Madam.
If you come to the, say, page 72,
Yes, madam.
uh,
Yes, madam. 72.
say, article number 4,
Yes, madam.
towards the end, you'll find status of the account is standard.
And there is no possibility of finance. Standard is a matter of accounting.
Account
practice,
number,
madam.
article 5, status of the account is standard.
Yes, madam.
So what is the meaning of standard? Mr. Chamaria?
Hello?
What is the meaning of standard? Account being standard?
That means this account is in consonance with the policies and standards that are to be maintained by the bank.
That is your interpretation.
No, madam, that's what is said, but
No, what is said here is the account is standard.
standard. Standard means it has followed the all the principles and practice.
Normally, whenever there is a any grant, madam, in form of loan or whatever, madam, suppose whatever normal accounts are there, madam, that would be treated in different categories, madam, so that my transaction whatever operated there on, that has been, madam, earmarked. Madam.
Sorry, I didn't get it.
Madam, suppose a person is a normal account,
That is
saving account,
standard.
current account. Sometimes suppose a person asks for loan, madam. Now that loan has to be granted for that account, madam, sometimes. So therefore, this account has to be treated in a separate manner.
Hmm.
Whatever transaction that in and out, madam, everything, madam.
So how does it define what is the meaning of standard?
Madam, your lordship will say at page 72, article number 4,
Ah,
the status of the account is standard and there is no possibility of financial loss to the bank.
that is what I'm asking.
Means the standard means it is not a bad debt or there's any chance of any loss to the bank. The borrower is paying the money regularly to that account. That's why it has been classified as standard. Otherwise, if sometimes it may go to NPA. This is a accounting phrase used for standard.
Then say, let us say you come to article number 10.
Yes, sir.
It says irregularities pointed out are actually inspection irregularities in nature.
Ah.
So what are inspection irregularities? And how does it differ from an irregularity which will have consequences of affecting your service?
Yes. Now your lordship will see what was article number 10 in the charge sheet.
Hmm.
Page number. $35.
Yes.
Page 35, madam, at Chazar. That said Roy during his above tenure at Panbaza Bank had acted in an irregular manner insofar, irregular manner insofar as he disbursed a car loan to so-and-so, account number so-and-so, in which remark of the sanctioning authority with his signature in the loan application booklet was not held. That means he transferred it to the superior authority, so he did not held it. Then signature of the borrower was not held in quotation pro forma invoice. Invoice or quotation, when you take a ask for a loan, some signature has to be there. But they have not said that whether there is manual for doing all this. Then signature of the borrower in PAN card differs with that of the in-loan document executor. Well, sometimes I even forget what I wrote in a particular bank, the signature, and the PAN card signature.
No,
is-
Mr. Moore,
Hmm.
you see, our scope of judicial review is limited.
Yes,
So all these interpretations, if you can point out from the banking regulations, we'll accept it or
No,
from certain judgments.
yes, sir.
But the what are the cardinal principles? That there is no evidence, or the charges are such, the charges are so vague, it cannot be replied.
Mm.
So these I don't think are ingredients here.
No,
So the only issue
Then-
issue to be seen is how the evidence against you
Yeah.
has been
proper-
taken by the inquiry officer.
Yes. And there, that's why I have given those list of judgment of the Honorable Supreme Court to show how the evidence has to be looked into it.
No list of Supreme Court judgments, you'll have to take the trouble of reading it to us.
Yes, I'll just given it because at the very first, without
Hmm.
letting your lordship looks into the facts, it was not
No,
proper.
no, that's all right. Let us complete the facts first.
Yes,
Let us complete the facts.
but against each of the, as they have held in the inquiry report,
Hmm.
that I have tried to put up a cock and bull story, and I have not replied specifically to the charge. That statement is wrong. Prima facie from the inquiry report at page 66. And your lordship knows that the role of the presiding of presentation officer and the inquiry officer is quite different. And we had taken a specific ground at page 63 that all the questions that which the presenting officer had put to the DO was prepared by the EO himself.
Presenting officer was appointed.
Yes,
Is there?
yes, ma'am. Page 63, your lordship will see even the ground number 1. The presenting officer was appointed on 25/6/2013 at page 108, madam. (108), it is their affidavit in opposition. Internal page will be page 14.
Yes.
108 is the inquiry officer and the presenting officer was appointed, madam. 108, your lordship got the document, 108.
Yes.
And we said that page 63, that all the questions that PO placed before the MW1 were prepared by the EO himself, and this is an example of biasness. Now, again coming to page 66. I have also gone through the representation of the charge officer on the findings of the inquiry officer submitted by his letter dated 2/5/2014, that is at page 63, wherein the auditor observed that he did not submit point to a specific reply of the charges level against him. And page 72 is the point as reply against point 1, which was submitted on 21/3/2014. Then second is, my lord, he attempted to submit a cock and bull story without going to the points. That is the charges framing.
Okay.
Now, the impugn order, your lordship will find. The impugn order, it starts from page 64. This is which I have just referred. Then against that, my lord, we prepared an appeal.
Impugned order is this is the
First impugn order is at page 64.
No, 64 is a disciplinary authority.
Yes. Then your lordship will find.
You're not challenging the inquiry.
No, we have challenged it.
Uh,
Your lordship will find that at page 70.
hmm. Yes.
Then against page 70, the second impugn order is at page 71.
Yes.
They did not decide to look into it because it was not filed within time.
Yes.
And why this was not possible? Because we have annexed the medical reports at page 68 and 69.
But it was not rejected on that ground.
No, it's just on the point of the limitation.
Was it rejected on the point of ground?
Well, page
Limitation.
Madam?
Where is that order of appellate authority?
71.
45 days. All right.
So we are against the two order. One is that against the finding of the disciplinary authority, and this is at page 71.
All right.
And your lordship has seen how they have dealt with the charges at page. Reply to itu নহয় এই ছোট্ট খালি activity নি হেৰি কৰিছিলে how they have dealt it your lordship has will find in their affidavit at page 111.
Hmm. Yes.
So if at page 112, the evidence vis-a-vis allegations and analysis of evidence, your lordship has to see whether it is evidence adduced by the department, my lord, even if it is taken at its face value, my lord, whether it can be held to be meet the burden of proof, namely preponderance of probability.
Yes.
As your lordship has said, that if six, because all this evidence, the burden of proof as per the criminal law and as per the departmental proceedings are different. But your lordship has to see that whether this evidence adduced by the department, my lord, even if it is taken on its entirety to be correct at its face value, then whether it meets the burden of proof under the preponderance of probability, my lord. Your lordship has said they have simply given the exhibit numbers, there is no discussion, nothing, and neither the contents were proved, neither when they say cross-examination at 116, they say whose crop. Well, my first ground, so far this is concerned, that no witness was examined to prove these documents, which are referred from serial number 6 at page
But
112.
the fact, is it your case that the charges are vague and you could not reply effectively? That is not a pleaded case.
No, that because I have replied to each of the charges.
So your first ground is?
In spite of giving specific reply to the charge, the inquiry officer has held that I have not replied to the specifically to the charge, and it is a cock and bull story.
Yes.
बाद में आएगा. There is, your lordship has said, page number 26, that is at page 66. The first, I have also gone to, he did not submit point to as reply to the charges leveled against him. To that, we have the counter at page 72.
Yes.
And it is dated 21/3/2014. And page 64, where this has been referred that I did not submit point to as reply, is after the after us is that is dated 26/20/06 2014, 20th of June 2014, page 64.
Yes. Okay.
Then he at serial number he said he attempted to submit a cock and bull story without going to the points that is the charges frame against him. Page 66. So at page 66, this is contrary to records, my lord. Simply discussing it and rejecting it is different. He simply says that you did not submit point to a specific. What can be more specific than which I have referred just now at page 72?
Yes.
Then the next is, my lord, so far page 112 is concerned. Serial number 6, evidence vis-a-vis allegations and analysis of evidence. Here, my lord, my first response is that they have merely tendered the documents and did not prove the contents thereof, which is not as sufficient. They have merely tendered the documents and did not prove the contents thereof, my lord.
Yes.
Then third is, my lord, no witness was examined to prove these documents.
Yes.
Then, my lord, whether this evidence, my lord, which is at page 112 and all, whether this evidence adduced by the department, my lord, even if it is taken on its face value to be correct in its entirety, whether it meets the requirements of burden of proof, namely preponderance of probability.
Yes. Yes.
And next, the disciplinary authority, my lord, accepted the report of the EO in toto. No independent finding, my lord.
Yes.
And the appellate authority's order, my lord, dated 14/3/2014, by cryptic order had just rejected my appeal not to be filed within the stipulated period of 45 days as per their regulations. So these are basically the points, my lord, which I have raised in this petition. Now your lordship will first see. But I don't think your lordship has online.
No.
No, then your
We
lordship
have online, but we are not connected at the moment.
okay. Your lordship will look
Yes.
into my book. I'll look from the tab. पहला वाला कौन सा दिया? हाँ? 2009 2 SCC,
ये सब निकालो.
page 570.
Hmm.
I have all the books, so I'll give it to her.
Hmm.
2009 2 SCC 570, paragraph number 14, my lord.
2009.
2 SCC
Hmm.
570, paragraph 14.
This is for what
Malad-
proposition?
My lord, that's why I have given in that paper. Oh. So that it becomes easier for my
Yes, para 40.
paragraph 14. I'll give the books, my lord. These are all laws known to your lordship. Just will rephrase it, my lord.
No, don't be so presumptuous. Para 14.
14.
Yes.
Indisputably, a department proceeding is a quasi-judicial proceeding. The enquiry officer performs a quasi-judicial function. The charges levied against the delinquent officer must be found to have been proved. The enquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during investigation by the investigating officer against all the accused by itself could not be treated to be evidence in the disciplinary proceeding. No witness was examined to prove the said documents. The management witness merely tendered the documents, just like us, my lord. The management witness merely tendered the documents and did not prove the contents thereof. Reliance inter alia was placed by the enquiry officer on the FI, which could not have been treated as evidence. Here also, my lord, the documents were simply tendered. Your lordship will not find a simple a simple utterance in the report that the contents were proved.
Okay.
Simply, my lord, just like in a criminal trial, if you exhibit the 164 statement, that will not prove the contents. The contents has to be drawn to the attention of the witness.
Yes.
Next is 2010 2 SCC 772. Para 27.
Yes. Yes.
A bare perusal of the aforesaid sub-rule shows that when the respondent had failed to submit the explanation to the charge sheet, it was incumbent upon the inquiry officer to fix a date for his appearance in the
Para 7.
27,
27.
27, 28, and 30.
Yes.
A bare perusal of the aforesaid sub-rule shows that when the respondent had failed to submit the explanation to the charge sheet, it was incumbent upon the inquiry officer to fix a date for his appearance in the inquiry. It is only in a case where the government servant, despite notice of the date fixed, failed to appear that the inquiry officer can proceed with the inquiry expertise. Even in such circumstances, it is incumbent on the inquiry officer to record the statement of witnesses mentioned in the charge sheet. Here, one witness was there cited by the authorities at just after the statement of allegation. Since the government servant is absent, he would clearly lose the benefit of cross. But nonetheless, in order to establish the charges, the department is required to produce the necessary evidence before the inquiry officer. This is so as to avoid the charge that the inquiry officer has acted as a prosecutor as well as a judge. Here, my lord, the questions that were put by the presenting officer were our specific allegation that it is drafted by the inquiry officer himself. It was simply put to us. Effort. Then paragraph 29. Apart from the above, by virtue of Article 311(2) of the Constitution of India, the departmental inquiry had to be conducted in accordance with the rules of natural justice. It is a basic requirement of the rules of natural justice that an employee be given a reasonable opportunity of being heard in any proceeding which may culminate in punishment being imposed on the employee. When a departmental inquiry is conducted against the government servant, it cannot be treated as a casual exercise. The inquiry proceeding also cannot be conducted with a closed mind. The inquiry officer has to be wholly unbiased. The rules of natural justice are required to so and so, or so and this. Then your lordship will see the next one. 2018 7 SCC, page 670. 2018 7 SCC, serial number 4. 2018 7 SCC, page 670, paragraph number 24 and 25. Page 670.
जल्दी चाहिए ना.
India business. 2018 7 SCC, page 670, paragraph number 24 and 25.
24 and 25.
Yes, ma'am.
Yes, please.
Why I'm pointing out to this paragraph? Because here, as I have told, that the inquiry officer had prepared the questions and that was given to the presenting officer to be put to us. But here, the court has emphasized on the impartiality role of the inquiry officer. Next. Next is, my lord, 2021 4 GLR. Mine is GLR. This is GLR. GLR 468. My lord, this is
GLT or GLR?
It is in the GLT as well as in the GLR. I have written it GLT. It is GLR actually. 2021 4 GLR, page 468. This is only for persuasive value because this is a judgment of the coordinate bench, my lord. Paragraph number 34 to 39. This is, I am citing only for persuasive value only, my lord.
Yes. Okay. This is on the same
Yes.
principles.
Yes, the disciplinary authority, on the other hand, accepted the report of the inquiry officer in toto without any hesitation, and no any appreciation was made on his part.
All right.
Similarly, the appellate authority and reviewing authority upheld the findings in the entire process. None of the authority has discussed any of the vital issues raised by the petitioner as mentioned above. The sole and the very basis of the inquiry was the various complaints filed by the complainant, which was taken up in the inquiry. Peculiarly, none of the original complaint was brought into the record, nor any author of the complaint was examined to prove such complaint. The entire proceeding kept into a nullity for the sole reason. The genuineness of the document was never admitted by the petitioner, neither the respondent authority deemed it proper to produce the original document, nor offered any explanation for non-production of the original documents, original complaints and the complainants, which has vitiated the entire proceeding. All norms of the rules and regulation as well as established principle have been thwarted by the respondent. As has been held by the Honorable Supreme Court in case Gandhi, that unless the rule expressly by or necessary implication excludes the recording of reason, it is implicit that the principle of natural justice or fair play does require recording of reason as a part of fair proceeding. In an administrative decision, its order decision itself may not contain reason. It may not be requirement of rules, but at least the record should disclose reasons. It may not like a judgment, but reasons may be precise. Further, it is held that strict rules of evidence act and standard of proof envisaged therein do not apply to the departmental proceeding or domestic tribunal, but must be proved by preponderance of probabilities. It must be German, relevant to the facts and issues, and the inference from the evidence and circumstances must be carefully distinguished from conjectures or speculation. The inference of fact must be based on evidence which meet the requirement of legal principle. In the said decision relied by the petitioner, it has been held that the appellate jurisdiction under Article 136, 226 of the Constitution of India cannot reassess the evidence and has come to its own different conclusion, where finding of facts recorded in independent inquiry are based on evidence. In the matter, we found that except some mere speculation on some disputed photostat documents, no any evidence was recorded. That which your lordship always says, that it has to be preponderance of probability, the power of judicial review in a departmental proceeding matter. Then paragraph number 36, as has been referred above, the banking authority has own prescribed rules and regulations regarding conducting of inquiry prior to imposition of penalty. But in the instant case, prescribed rules were not followed by the respondent authority. The findings of the PO and the inquiry officer is based on the observation on the documents that was produced, but none of the concerned persons like the complainants and the person from the bank authority was examined to prove the phantom of non-withdrawal of the loan amount from the KCC. Whatever was written in the photocopies of the complaints and other documents was taken into account while arriving at suspended. As has been held in the aforesaid decision, nature of the departmental proceeding is a quasi-judicial one, and where the findings of the respondent authority is based on no legal evidence, and the conclusion is one to which no reasonable person would come, the findings can be rejected as perverse, and the inquiry suffers from additional infirmity of non-application of mind and stand vitiated. If such finding of guilt is based on no evidence, it will be amenable to judicial scrutiny. As has been held in Nirmala Khala's case, it has been pointed out that judicial review is confined to correct errors of law or procedural error, if any resulting the manifest miscarriage of justice or violation of the principles of natural justice. In the present case, the original complaints were not placed on record, nor any other witnesses were examined. And the absence of original complaint indicate that there was in fact no complaint in existence which support the contention raised by the petitioner that loan was duly disbursed to the person concerned, and whereas no bank official has been examined about non-withdrawal of amount. The inquiry officer failed to hold an impartial domestic inquiry, which is the essential component of the principles of natural justice. The faulty reasoning of the inquiry officer attributing guilt to the petitioner even after non-production of the complaint has made the inquiry as biased, perverse, and against the principles of natural justice. A person has been removed from the service by such department inquiry, which is per se illegal. All the authorities have closed their eyes to the findings of fact that it is not supported by evidence at all, but on speculations and conjectures. It follows from the foregoing discussion that the
that is in line of the
yes, all the
judgments of the apex court.
Yes.
Yes.
And
Next.
in this case also, if your lordship looks in the record, what I have stated will be proved from the record.
Next, you are referring to some Allahabad judgment.
This is my lord, your lordship will find it I have the online, because these are the persuasive value. I have given the online citations. I have my online, but your lordship told that your lordship is not connected. These two, I have discussed the principles at paragraph number 10 and 40, in the judgment at paragraph number 10 and 14 at serial number 6, and at serial number 7, it is paragraph number 17 and 18.
This is to the effect that the
That first statement.
findings
Yes.
must be reply specific.
Yes.
Yes, okay.
Then second one is also I have that is
Yes.
so these are the citation which I have realized. I have the online one.
Hmm.
Actually, my lord, nowadays we are trying to be
No, no, you
paperless.
must, you must, you must. Absolutely.
Paperless. I don't know, my lord. My lord should also be given.
We can be, provided the bar in its entirety decides to go online, we can be, would love to.
No, my lord. For looking at the citation, my lord, at least your lordships will use the laptop nowadays.
Uh,
Because otherwise, my lord,
See, the problem with being online, looking here, is that we don't look into the judgments that you point out. We are at liberty to look into other judgments also.
yes, your lordship.
And then when we put a query back, we don't get a reply. But the judgment you are referring to
Yes, sir.
has been, the principle has been watered down, or a different view has been taken,
Yes, sir.
for which we don't find the reply.
No, madam, we'll cross check in the nowadays too. Immediately we can cross check.
I'm
and
not,
for-
I'm not referring to you, Mr. Kumar,
Yes, sir.
but generally. So
Madam,
we
gone
find
are
that, you come up with one or two judgments and then
Yes.
you stick to the judgments.
No, that will be wrong.
Hmm.
That will be wrong.
So when we go online,
Yes, sir.
we have the liberty to go beyond.
Yes, yes.
Come back.
Yes, I have given that 7. Your lordship can look into the law that has been developed after this judgment also or later. That's. But now gone are the days, madam, when we
The
can show a
suggestion-
overall judgment. To the,
This request of the court is this looking in the past and looking beyond is an effort to be generated from the bar so that it quickens up the disposal.
Yes.
That if that happens, then that is the best. That is the advantage of having an online.
Yes, ma'am.
All right. These are your cases.
These are
So
the-
essentially,
the general grounds will always be
so
there.
you're essentially what you're saying is that that these charges which you have replied
Yes, ma'am.
had not been dealt with effectively by the inquiry officer. It was not proved in a manner required to be proved. Therefore, the charges have not been driven home.
Yes.
And consequently, the
documents have
appellate
been tendered.
authority accepted and sustained the findings without any application of, I'm sorry, the disciplinary authority.
Yes, ma'am.
An appeal was
took-
rejected on the ground of delay. All right. Mr. Chamaria.
My lord, my turn. No, lordship, the story is not that much of easier, as my learned senior friend has pointed out.
Hmm.
No, lordship, my learned senior friend has addressed this honorable court questioning the inquiry. But lordship, thing is that once he has candidly admitted the irregularities, I will show, lordship, nothing survived, my lord. Second point is that, my lord, now we are under 226, my lord. Lordship has already pointed out limited jurisdictions, violation of natural justice, my lord, disproportionate, or these are the two things.
No, but if he is admitted, why did you go for an inquiry?
Lordship, what I'm saying, my lord.
The inquiry is to find out whether these
Exactly, lordship,
charges or
inquiry,
allegations are
I
valid or
think
not.
This is a very perfect inquiry. In my, I will come to that inquiry that what are the ingredients, otherwise, lordship, sustainable. Now, lordship, the first point that has been addressed, that is itself is wrong. The Carl loan was not only the issue. Lordship, just have a look. First, so-called notice. I'm
What
just
are-
referring two or
What
three
are these
documents.
documents you're giving us?
Lordship, so-called notice, my lord. These are part of record, my lord. I have, my lord, just first so-called notice, my lord.
Hmm.
5/3/2013.
You refer to the documents in the pleadings.
My lord, so-called notice, my lord, what happened, my lord, neither they have enclosed, but we have also failed to enclose in our affidavit. But lordship, just it is otherwise the reference of, my lord, in charge sheet also, but some matters are there, my lord. Only one line, my lord, I'd like to read out, my lord.
Show cause notice.
My lord, so,
Okay.
first page, my lord,
One
can you see?
minute,
5/3/2023. Orange flag, my lord. During your tenure as the senior manager advance of Panbajar branch, a large number of cars were financed under bank's car finance scheme. Two public irregularities has been observed in 131 car loans account, one housing loan account and one mobile loan account which were financed during your tenure as senior manager advance of Panbajar. Almost in all the cases, neither the signature of the then chief manager or sanctioning authority was held towards sanctioning of the car loan proposal, nor a note has been put before the chief manager of the branch in shape of the consolidated statement in a particular month of sanction for ratification of your action according to the bank norms. However, while sending the monthly MDM statement to the general office, signature of the both you and the chief manager are there. The common irregularities are as follows. Loan application form not completed, remarks of sanctioning authority column given on page 4 of the application form left blank. Credit report of the borrower and guarantors are not properly filled up and not authenticated in some of the cases. KYC norms not adhered to. In most of the cases, there are no signature of the borrowers in a quotation submitted by them to the branch for sanctioning the car loan as per record. In most of the cases, margin money was not deposited with the branch prior to the disbursement of the loan. There are also no proper receipt of depositing said margin money with the dealers. Delivery orders are not held with loan documents in most of the cases. In several cases, the cars were delivered by the dealers to the loanee before sanctioning disbursement of the proposal at your end. KYC documents of the borrowers and the guarantors are held in respective loan file, but these documents are not authenticated by the officers of the branch. Types models of car mentioned the quotations kept in the record of the branch official in the most of the cases with the types models of the car mentioned in the sales certificate and registration certificate.
Please come back to the first page.
Madam. Yes.
Uh, in the recital,
Madam.
you mentioned that signature of chief manager sanctioning authority was not there,
Madam. Very important part, my lord.
but during sending of MDA means
My lord, there is, my lord,
what
after-
is MDA
My
statements?
lord, this is a statement in compiling the old loan that has been granted to send to the higher authority. Nominee signature, but the exercise has to be contemplated by the advance manager, my lord. Because each and every document is not possible to perish by the chief manager once it has not been placed before him, my lord. Now there are numbers of my lord transactions that have been happened in a bank, my lord.
He is the advance manager. He is the senior manager advance.
advance manager. He is the final authority to sanction all things.
Uh,
Now, lordship,
so
column,
his signature is there.
his signature is not sufficient, my lord, because he only
Whose
possesses-
signature is necessary?
My lord, chief manager, he is the sanctioning authority,
So
final.
chief manager has signed it later.
No, my lord, sign the letter of the compilation of the entire, because my lord,
So
numbers of-
have you drawn up proceedings against the chief manager?
my lord, chief manager is otherwise not responsible in what manner?
Why?
Lordship, I make the position clear, my lord. Just give me a little time. Lordship, advance manager deal with the old papers, etc. work. He made everything, my
I
lord.
agree. But monthly wise or periodically, you send these documents to the some higher office, zonal
Right.
office, head office, wherever.
Right.
These are then at the prior to being sent, they are being signed by the chief manager.
My lord.
Now, how is the chief manager?
My
The
lord,
moment the chief manager signs.
My lord, a final sanction letter comes before the chief manager. He put the signature, but entire.
No,
record has
we are
to be-
not about sanction letter. You see the last line. However, while sending monthly MDA statements
My lord,
to zonal office,
my lord.
signatures of both you and the chief manager are there.
Yes, my lord. There is no dispute to that effect. Both signatures are there, my lord.
Hmm.
But the process, entire document examination, everything, the job has to be conducted by the concerned, my lord, that dealing with officer. So therefore, my lord, this has been taken into consideration inquiry officer.
Now,
and evidence also.
the consequential query would be how much of pecuniary loss was caused to the
My
bank?
lord, that has been, my lord, 1 crore 89 lakhs pecuniary loss has been caused. That is the part of record which speaks about, my lord.
Not recovered. Bad debts.
No, my lord, that is already pointed in the office file, my lord.
Uh.
Now, lordship, just my lord,
Bad debts.
So it is not well stated.
my
as
lord,
bad
11. My lord, may I come to next, my lord, sir?
11, yes.
In several cases, the cost of the vehicles delivered to the boards are less than the value mentioned in the quotations in the same. Also do not tally with the loan amount disbursed as per the record held with the branch. In several cases, sales certificate, registration certificate, etc. invoices are not held in file.
No, these you'll have to point out at least sample cases, 2, 3, 4 cases
Madam,
you'll have to point
that's
out.
one because my
Yes.
thing is that let us see that what are the so-called notice and that has been followed in my otherwise my lord in the charge, my lord.
Hmm.
Now, Lordship, finally, in view of the above gross serious irregularities committed by you at the time of sanction disbursement of the credit facility terms loan of the above mentioned borrowers, bank precious fund and also image are in jeopardy. Clearly mentioned. You are therefore called upon to stop us during 7 days. Now, Lordship, this is the foundation of allegation. Now, straightway I am coming to my lord. My lord, I'm coming to my lord the inquiry, my lord. That is very important, my lord.
Hmm.
Lordship, in my affidavit, I have enclosed, my lord.
No, from this bunch, is there anything else you want to point out?
Yes, my lord. One letter only. Last, my lord, purple flag. Last page, my lord, where he has submitted in respect of the so-called, where he candidly admitted all allegations. Almost, my lord. Last
Then-
page, my lord, purple,
Huh.
handwritten. Earlier, he has referred every transaction detail.
Please,
Now,
please read that relevant portion.
my lord, respected, sir, Lordship got it.
Yes.
Respected sir, you may kindly agree that I have not violated any norms of the bank which may jeopardize the interest of the bank. There is no malified intention on my part, even if there is a feelings shortcoming.
Little shortcoming.
Yes, my lord. Here and there, it was in the name of attracting customer to the bank again, competitive situation and to fill up the target of the retail findings lending at the branch whenever I did it with full concurrence of the incumbent. Kindly do not consider the irregularities gross or serious because bank interest is intact in all the cases referred in your above letter. I may also mention here that when such loans were disbursed to fill the target of the loan under retail trade, we have to feel aggressive and were reporting the progress to the journal head as and weekly basis. The irregularities are of routine nature and can be verified even now. In view of the above, I request you to consider my case and a sympathetic service. My lord, he has clearly admitted about irregularity. He said that because there is a competition, then he can be, my lord, do anything whatever he like, my lord. Now, Lordship, kindly see whether this element, my lord, supported by the inquiry officer or not. Straight why I am coming to Lordship, my affidavit in opposition. Affidavit in opposition, my lord. And the relevant part, my lord, cross-examination, page 22. Every exhibit has been examined, my lord. That is a reference from the beginning to end, but I am coming to the concluding part where, my lord, cross-examination, lordship, page 22 of my affidavit in opposition.
Yes.
My lord, page 22, lordship, each line is very important here. Defense Exhibit D1 MDA statement tells about the reporting of the sanction loan account to the Journal Office during the period of June 2009 to November 2011, but it does not mean that the said loan account has been duly sanctioned authorized by the sanctioning authority of the branch chief manager. Moreover, MDA statement copies are not corroborated by the supporting document is acknowledgement of MDA relevant pages of dark registers. Most of the loan linked SB account are opened by the CEO himself. Unduly normally might be opened authorized by the manager or other officer of the branch and without taking supporting document confirming KYC compliance or verifying the same. CEO cannot exonerate from the omission commission committed by himself by stating such type of comment in his reply given as under. The irregularities pointed out in the charge sheet are inspection irregularity in the nature. Sanction of the loan were reported through MDA. It does not mean that loan were sanctioned by the authority concerned chief manager of the branch. Defense in the signature could be for many reasons. It is a hypothetical argument plea in respect of the borrower's guarantor signature differ in the different document. 4. Document were obtained by the undersigned CEO which are not found now in file for reasons not best known to you. That is his admission. It was procedural lapse done inadvertently, he admitted. Lapse were inadvertent, bona fide, and may be attributed to excessive work pressure for growth of the credit to the work. I have already referred, my lord. Remark space blank normally mean there is no adverse remark, but remark space is meant for the sanctioning authority commitment remarks about sanction. CEO submissions reply against PO brief differs many a times in respect of the irregularities pointed out for proved during the course of regular hearing process and which were duly accepted, authenticated by him in the regular hearing proceeding register also. For example, Article 1, number 2, as per regular hearing proceeding, copy of bill, sales certificates, bank check, final invoice, not taken, held in file, which are also certified by the present branch manager, but in CO reply stated that only RC not held in file, but in charge sheet no charge frame in respect of RC. Similarly, CO statement differ in most of the cases of article. On page of the CO's reply, it appears that he attempted to submit a coke and bull story without going to the points that is charge frame against him. Therefore, the charge frame against Ambika Rai Solanki has been proved. Now, Lordship, this is the finding inquiry where, my Lord, suppose we fail to appreciate certain thing, but he himself admitted that any lapse, my Lord, if bank feels that this lapse is very serious in nature, it may not be a good precedent for any others, my Lord. On the basis of that, my Lord, even taken into consideration all this material, how this, my learned senior friend is pointing out that disciplinary process, my decision-making process at the time of, my Lord, taking removal has not taken into consideration. This is also not packed. Lordship can have a look that part also. My
No,
Lord, decision, my Lord,
These are normally required to be part of the pleadings. Are they part of the pleadings?
Quite right. I'm sorry, my extremely sorry, my Lord, because, my Lord, what happened earlier, my Lord, this is a very old matter, and, my Lord,
No, old matter is okay,
my
but
Lord,
this bunch of documents,
quite right. My Lord, page 64
in
of
the
my,
event we hold against them, this will be the first ground that documents relied upon were not part of the pleading.
my Lord, this reference other charge sheet contain, my Lord, this
Mhm.
letter, other, my Lord, page 64, the decision, my Lord. Decision,
Of,
read petition, my Lord. Read petition
Read
filed by
petition.
the, my Lord.
yes.
Now, Lordship, it is a 5 pages, 4-5 pages, my Lord, judgment in respect of this whole issue. And Lordship, can you see that what material that has been taken into consideration might be lapse, but whether the thing which is otherwise required to be considered has been considered, that is very important. Now, Lordship, page 65 is relevant.
This is the disciplinary authority.
Yes, my decision of the disciplinary authority, because my Lord, he is pointing out that no application of mine.
No, first you tell us about the inquiry report.
My inquiry report I have pointed out. Inquiry report found, I have given Lordship, just now I have referred that entirety of that inquiry report come to the conclusion that there are so many lapses in respect of dealing with the papers and everything, my Lord. Now,
You take us to the inquiry report.
yes, my Lord, okay. My Lord, my affidavit in opposition, page 22, and the inquiry report start from page 17, my Lord.
Yes.
If I do this one, it's not very good.
Now you see the gist of the allegations and then evidences and allegations.
My Lord.
Charges framed against so and so, charges proved. How is it proved?
My Lord, kindly see that the evidences start from paragraph.
There is no discussion.
My discussion is there, my Lord. That's
Where?
why I'm saying, my Lord, paragraph 6 is the all document under references in respect of the all, and my Lord, each and every allegation has been treated in the light of the papers, and it has been,
No, where is the discussion in the inquiry report?
my Lord, there are, my Lord, more than 100 charges.
Whatever it may be.
And my Lordship, kindly see, in respect of all charges, after verification of the document, they come to the conclusion charge proof. Now, each and every document, again, my Lord, required to be referred. Is it, my Lord, possible, my Lord?
We don't know. We are asking you from this, from page number 18,
My Lord.
para number 6 onwards,
My Lord.
are the charges being discussed by
My-
the inquiry officer, giving reference to the material exhibits
My Lord.
and saying that the charges are proved. Now,
Lord,
can
yes.
you say, point out any charge
My Lord.
and understand on what basis these
Quite
charges
right.
have been
I'm
held to be
pointing out
proved?
middle line number 4, my Lord.
In page number?
Page number 18, column
number
6.
Yes.
Now, kindly see
Hmm.
that the pro forma invoice quotation of the car not accepted signed by the respective borrower as per the management exhibit so and so, so and so.
Hmm.
Therefore, this circle of entire document has been taken into consideration.
So these
examined.
material exhibits refer to what?
My Lord,
Whose material exhibits?
my Lord, material exhibit is the
How is
part-
how was it confronted to the delinquent officer?
my Lord. So far, this
What was the
documents are
what
concerned.
was the presenting officer? How did he present the case?
My Lord, so far these documents are concerned, that has been brought on record at the time of my Lord inquiry.
Mr. Counsel, You are holding an inquiry.
Right.
You say that he has admitted. Now you have to first tell us if he has admitted, why did you bother to go on an inquiry? He has
My lord,
admitted.
my lord, question
Hold him
is that,
guilty.
my lord, admission.
You chose to go on an inquiry.
Right.
The inquiry is for the purpose to find out whether the charges against him
Right.
are brought home on the basis of
Records.
record, evidences. If the inquiry officer is of the view
My lord.
that the very purpose of the inquiry
My lord.
is to ensure that the charges are proved,
My lord.
then prima facie this inquiry is bad in law.
In my view, my lord is quietly, rightly pointed out. My lord, what happened? My understanding is that my SOFA inquiry officer is concerned, at the time of inquiry, my lord, whatever record document that has been brought in respect of the, irrespective of the charge that has been taken into consideration, and my lord, finally,
That's what
the
I'm
com-
asking you.
Yes.
Taking into consideration is not reflected from the inquiry report.
my lord,
Now you'll have to support
I
it
will not, comment
by
on
the
that.
record, by the records.
Lordship,
That is what
lordship,
I'm saying.
But lordship, thing is that the.
It was, we are
my
not
lord,
giving you an advice, but it was
lordship,
open to you to bring out the relevant records on the pleadings to show that in the context of the inquiry report, this is how the inquiry was conducted.
my lord, lordship, rightly pointed out, if suppose lordship believes that it required or more details or whatever, lordship, lordship may take consideration that way as lordship deem fit for that. But so far, these pleadings, what my learned senior friend is advanced in his read petition. I have gone through, my lord, the most important part he has failed to address, that is disproportionate of punishment. One of the ingredients,
Oh, Mr.
natural justice.
I'm surprised that he has not even taken this is passing thought in my mind. Don't take it other way.
Lordship, my duty is that because what
He
grounds?
is not even, he is not taken up the point that the charges are vague
My lord,
on the basis of the allegations.
my lord, so far,
How
my
does
lord,
he meet the
my lord,
charges?
my lord, kindly see the consistency, suppose notice, charges, and inquiry. In between, my lord,
You are following the procedure, no doubt about it.
my lord,
But from the procedure you're making, you see, you are an astute lawyer, a seasoned lawyer.
my lord,
Let us say in a criminal matter,
My
you have a charge sheet.
my lord,
And
absolutely,
the charges will have to be framed under a particular head
my lord,
so that the accused can go and
my lord,
defend
kindly,
his
lordship, may kindly,
allegations.
kindly see from one perspective, my lord, a inquiry
You are
officer-
bringing out 100 and something charges.
130.
Now these charges, you have proceeded with an inquiry.
My lord.
You will have to hold each and every charge, how it is proved, what are the material,
lord,
who are the witnesses, what was
Lordship
the
observation pertinent, my
basis,
lord.
what was his reply.
I'm not, my lord, denying that part, my lord.
And
Sometimes, my lord, we have to also see from the ground reality that these are not a trained officer to conduct the inquiry, my lord.
very well, but show us from the records that it was
That
done
in
at
what
least.
manner a particular, my lord,
Show
yes,
us from the record. We are only examining whether there is any biasness by the bank authorities.
Well,
That's all.
no,
Prima facie, this report appears to be not happily worded. Let us put it that way.
we leave it to a lordship. Lordship, I cannot.
No,
my
we
lord,
don't
make
want
any
you to
comment on
leave it
that.
to us. We are asking you for assistance
My absolutely.
to
my lord,
tell us that this order, this inquiry report
Inquiry report.
is supported by the
My lord, more material.
necessary
if suppose ought to be, my lord,
procedures, all the
It
procedures have
gives
been.
the picture more clear, my lord.
Hmm.
Now, lordship, kindly see that I leave to your lordship this point that whether this is in the light of, my lord, the thing ought to be done, has done or not, my lord. Now, second point I'm coming to, my lord. So far, my lord.
The first point itself, we are not happy with your answers.
My lord,
Before you come to the second point, your
my
entire
lord, my
entire
lordship,
blank,
I can-
Mr. Chamaria,
my lord,
Mr. Chamaria, your entire basis of defending this case
no, if
comes up
lordship-
from the inquiry report.
Absolutely. If lordship found that it required more
If the
elaboration-
inquiry report goes, all consequential actions go.
Absolutely, quite right. There is no
So
need-
trying to defend other actions
whatever. my lord.
without first answering the queries of the court in respect of the inquiry. What do your records reveal?
My lord, so far, my lord, my understanding is concerned, my lord. In case of loan matters, my lord, papers are the ultimate, my lord, genesis of the inquiry, my lord. And suppose if there is a totally oversight over that, none of the document has been tested, and my lord, the arrival of that conclusion, my lord, absolutely, my lord, say, my lord, I feel that it will not stand. But here is the case, my lord, each and every charge, irrespective of that, documents which are otherwise relevant, that has been looked into. Might be, my lord, it is a one line or two line. It may be more detail, or my lord, it requires, suppose, in if you lordship, suppose, observation. But lordship, if we look from the beginning to end, every charge is connected to the document has been taken into care, man.
Now you say there is some huge amount of losses.
My lord.
Where is that?
Flag, lordship, in file I have also mentioned, and my lord, it is also from the disciplinary proceeding, my lord, page 64, my lord.
Have you brought it in your affidavit?
My lord, so far, my lord, documents we have brought, lordship, decision of the disciplinary authority itself reflects, my lord, about loss, my lord. Page 64, the read petition. Just for a moment, my lord. Page 64, the read petition.
64.
My lord, 64.
Yes.
Now, lordship, kindly see the first line begins from what contention. Here, the Ambika Roy, while past posted function as a senior manager advanced at the bank Panbajar so during the period of 2008 to 2011, is alleged to have committed certain commission and omission which are serious in nature.
See, the disciplinary authority order appears to be an order which is trying to fill up the gaps in the inquiry report.
No, lordship pointed out about my loss, my lord. That components I just want to address.
Yes.
Now, violation of so and so amounting to misconduct under regulation 24 of the regulation, due to which bank has incurred activated loss to tune of 1 crore 80.
So that has to be on the basis of facts.
Matters are there, my lord.
That is what I'm asking you. Where?
My lord, once
Where are the materials?
my lord, loan has been sanctioned in different heads, my lord.
Ah,
My lord, they have found that certain amounts may not be, which has not been recovered, or my lord, which has been sanctioned out of turn.
Mr. Chamaria, this statement has been made on the basis of certain facts,
Material.
some documents. You
Supplements, my
produce
lord,
on a give us some
supporting, my lord,
specific cases, one or two specific cases to show that in these cases, the loan was sanctioned because of these issues, the amount could
But
not
it
be
required
recovered. It
more
is possible,
details.
listen, Mr. Chamaria, see,
my lord,
in a normal proceeding, in a normal case,
Right.
a person goes to a bank,
Right.
all the documents are filled up. Even then, the amount could not be
Right.
recovered, which is why the accounts are treated to be NPA
Not in
and
conformity of
proceedings under Surface E are initiated.
but that substantiation.
Now, will it be considered to be a fault of the bank officer who sanctioned the loan?
My lord, here,
You show us.
my lord, so far, the articles are concerned,
Hmm.
where, my lord, the amount which has been disbursed on account of different heads, that has been pointed out, and lordship, if required, my lord, detailing of that thing, we will place it, my lord, because this point is recently, my lord, just now, my lord, it is dropped up that detail of 189 required.
It is your case
My lord,
that there is a pecuniary loss as referred to in the order of the disciplinary authority. Now, there is no reference in that order to say that XYZ loan accounts, because of his default, the recovery of the
No such
amount went
statement.
back.
Quite right, my lord. Lordship, so
There
far
has
this-
to be some correlation.
Absolutely, quite right. Now, lordship, this material right now I don't have. If lordship direct me, then lordship I will also discuss with my lord concerned client.
Look, there is nothing on record.
Lordship, let me complete, my lord. Let me
No,
complete.
I'm
my
not
lord.
interpreting. There's nothing, whatever is, because you are kind enough to show us the record.
Absolutely, that is my duty, lordship. I have not forgotten.
There's nothing on record.
Now, lordship, may I counter two or three, my lord, stand if lordship permits about their saying, my lord.
So we'll hear you. You first satisfy
Right,
us on this.
Okay, my
We'll take it up on 3rd October.
3rd October.
You need not be there. You can request somebody.
Your lordship, some other day, third, I have a matter in the Supreme Court.
You don't have to be here. Not that we dislike
Yes,
your
sir.
presence, but we'd like to hear him on the basis so that there's
Yes, yes.
continuity is
Fine.
there.
Yes.
We'll not pass any orders in your absence. Let
No.
us, if he has any documents, let us
Yeah.
examine it.
But so far, what my learned friend has said, as it also has fallen from your lordship,
Hmm.
that although I have not taken the ground of charge to be vague or it's not clear, but even then, my lord, the procedure that has to be followed against the delinquent has to be in fair and it should follow the procedure laid down by the bank. And here, although they have said that certain procedural lapses are there on the part of my, but have those documents been produced before the inquiring authority to show that because of this lapses of this office memorandum, simply they have quoted the regulation provisions and they have done nothing. I have checked the record on the last occasion along with my junior, and I have find that in the record there is nothing such there. Man. And now today also they cannot come and say that anything that which travel beyond the charges that have been framed against me. They cannot bring new things into record.
No, since they're already producing the record,
Yes.
we
In
don't, we
record there is
are
nothing.
not giving them liberty to file any pleadings.
Yes.
We're asking them if there are any records to sustain the findings of the disciplinary authority.
But surprisingly, no. That to that extent, my friend is fair enough to say no, but he will inquire whether there is any other record.
He has not said no before us.
Ah.
He may have said no before you, not before us.
So
So
that is record is there. Record will speak for
But
itself.
lordship, he enjoyed 3 years, my lord. He enjoyed 3 years.
No, my
And
anxiety-
he has left no single
No, my-
application
No,
rejected, everything.
my today what I was reflecting is that as a counsel, there was lapses on my part also because I had filed this writ petition in 2015. I myself did not take any steps to conclude the hearing of this. And today on 23, I realized that this person is going to retire. So I have in my office itself to be vigilant against filing and forgetting about the files.
some interim order is there.
Nothing,
No, no, no.
nothing, my lord.
They were
And
seeking termination,
removal.
interference, removal, improvement, interference.
Because I also kept it.
Otherwise,
kept it
one
in my
period become
chamber for
infractious, my lord.
8 years.
All right.
My lord, that-
On third. Mr. Kumar, you have some problems on third.
Fifth.
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 We can have it on fifth. All right. Prefer
There's some matter. for
further
change.
hearing on fifth. Mr. Chamaria, learned counsel for the respondent bank, craves leave of the court
Yeah.
to produce certain records. Therefore craves a praise for further time. Accordingly, let the matter be listed on 5th October.
Well,
Mr.
so
D.
can it be
Kumar,
kept on top,
assisted
my lord,
by
because otherwise, my lord, it's suppose.
Huh?
Can it be kept on top, my lord, because only we have to produce.
You
Otherwise-
mention it. You are entitled to mention it. I'll
Yes,
give you the
okay,
liberty.
okay.
Yeah, please take back the records.
My lord. But.
Lenny. Scan for you. Thank you.
Yes, Mr. Bora.
My lord, by last order, your lordship directed us to produce the marks obtained by some particular rule numbers, my lord.
Hmm.
The list I have produced, my lord. In the list, it shows that the marks obtained by those rule numbers, my lord. In the written test, phase 1 means, my lord, written test. So in the written test, these marks have been obtained. And ultimately, my lord, 4 of them have been selected for the Vaibhavosi, phase 2. And in
It says not selected.
they have not been selected in the Vaibhavosi. Ultimately, they have not been selected.
That's what I'm saying. So ultimately, they were not
No,
selected.
not selected, my lord.
Right. And the petitioner did not appear.
Petitioner, my lord, serial number 5.
He was not qualified.
He did not qualify for the phase 2 because the cutoff mark for general candidate was 76 and he secured only 53, my lord.
And the other 2 did not appear for Viva.
He did not appear, my lord.
So there it is.
The first phase result was declared on 21/10/2019, Lord.
Hmm.
And thereafter on 24/10/2019, the petitioner filed an application under RTA Act taking some information regarding the answer sheet of this particular candidate. But they did not supply it And even after passing order by the commissioner, RTI commissioner, they did not supply it. And ultimately, what is they supply one information on T2 2021. Only stating that the petitioner get only 63 minutes. But other two answer they did not supply. An example number 5, page number 25. Lord. There are 3 questions.
25.
Yes, sir. Page number 25.
Yes.
This is the type of the RTI application. And in RTI application, question number 1 is answer sheet of the candidates appeared in the examination bearing roll numbers to answer. But they did not supply this. Sir.
Now you've got it.
No, this is the
These roll
Roll
numbers are
numbers.
different.
only roll numbers they given presently.
Huh?
The 4 years. The marks given.
These are the roll numbers
These
which
are
they've
the
given
roll
now.
numbers, and they get these marks like this. And my specific question was that answer sheet of the candidate.
My lord, that is not the pair in the writ petition, my lord. In the writ petition, my lord,
Already in the
provide.
Where is there?
No, but why do you want answer sheets of these? They are not selected.
Not project. First phase, these candidates are selected.
Huh?
In the first phase of the interview, these,
Maybe they are selected in first phase, but ultimately they were not selected.
Not selected.
in second phase, they are not selected.
Not selected. Now you are said to be not qualified for phase 2. Why was he not qualified?
Because the cutoff mark of phase 1 is, my lord, for general, it is 76. And the petitioner secured only 53, my lord. Serial number 5, my lord. So the petitioner.
Then why did you put 73 and 70 to be qualified? Because they are OBC.
OBC, my lord. Cutoff mark for OBC, MOBC is 68, my lord.
For general, it is 76.
76, my lord. And cutoff
Yes.
marks for phase 2 is
Second
also, my
phase
lord.
is, according to them, the second phase is 5.
Hmm?
Second phase is not 5.
What is second phase?
Second phase interview is not 5. From the annex number 4, page number 21.
Document.
Page number 20. It is not 5. Second phase interview is not 5. Second phase is ORM schedule.
No.
This
OMR test. Yeah.
this is not 5.
Second phase OMR test.
Yes, sir. Anyways, my lord, in the second phase also, the cutoff marks has been mentioned here, and these particular rule numbers did not obtain that, my lord, cutoff mark. So they have not been selected, my lord.
You want your answer sheet.
Yes, okay. My answer is and along with this roll number.
The other answer
Other
sheet,
answer sheets, why do you want?
probably he is not entitled for other answer sheets, my lord.
Regarding if I am not entitled for that particular answer sheet of the other, in that case, the SPI have to take some step regarding third party interest. They have to make an notice to the to that particular person within 5 days after receiving the party application. But they did not take this step also.
There is an RTI appeal if you should have
Yes,
gone.
sir. There is an RTI appeal also.
That is a
And
separate.
in the RTI appeal order was first on 28/10/2020,
Number?
page number 32. Last paragraph.
There is a direction.
Yes.
So was it furnished?
No, direction to furnish as per the provisions of the RTI Act.
Yes.
So answer script of the other person, it is a third party, my lord. Probably.
But they did not take the.
My
step
lord, that is
regarding
not
third
the
party.
subject matter of the writ petition. Even prayer is not there. To that effect, there is no prayer, my lord. Your lordship may consider his prayer portion at page 13, my lord. Setting aside and quash the impugn selection and appointment in respect of the specific rule numbers mentioned in the RTI application. So these rule numbers have not been selected, my lord.
So what do you have to say? But you have received your answer sheet.
No,
Your answer sheet
not received,
not received.
not received. They did not supply my answer sheet.
Why have you not supplied?
The direction of the RTI commission order.
Mr.
they did
Bora,
not supply.
there is a page 35.
Yes, my lord. I have seen.
What
my
is
lord.
that 35? You have given the information, but you did not submit the answer sheet.
Yes.
Why has it not been done? You submit the answer sheet. Give him a copy.
My lord, his answer scripts probably maybe.
Not
furnished to him.
probably, there is an order of the appellate authority.
But there is the order, but in prayer portion, my lord, he doesn't have any kind of such prayer.
May
my
not
lord.
be, but this order is there.
Yes, my lord.
You give him a copy.
Yes, my lord. His answer script. His
Your
an-
other praise we cannot
Yes, my lord.
accept at this point.
Yes, my lord.
Only thing we can say is that since the RTI authority has already directed, and the authorities will give you the copy of the answer sheet within whatever period,
Answer sheet of the petitioner, my lord.
petitioners.
Yes, my lord.
But we are not answering the writ petition in respect of his challenge to the selection process.
Selection process, what is the basis of his allegation? What is
So the basis of his allegation is that he wanted the answer sheets.
his
once-
basis is that, my lord, the roll number mentioned in the RTI application, they have been selected and appointed superseding him.
Hmm.
So the record shows that, my lord, they have not selected and they have secured more marks than the petitioner in the phase one, my lord. So the petitioner did not obtain the cutoff mark, my lord. So these prayers, my lord, number 2 prayer, setting aside and quash the impugn selection and appointment in respect of the specific roll numbers mentioned in the RTI application. So they have not been selected, my lord. So on what basis they now, if they would have been selected, there is a allegation of any arbitrariness or malafide or anything, my lord, then it could have been, my lord. But there is nothing to prove that, my lord. So that. And on the other hand, my lord, the numbers that I have produced before your lordship, it shows that, my lord, his all allegations are baseless, my lord. His third prayer is to consider his case for appointment to the post of grade 4, whereas he did not obtain the cutoff mark, my lord.
Getting the
Yes, your only ground is the apprehension that less meritorious people have been selected, bypassing your claim. That is not the correct case. You bring it on record.
Yes, sir.
You get it on affidavit, file it, bring it on record. Let him bring it on record. Heard learned counsels for the party, Mr. D.P. Bora, learned standing counsel, has produced a copy of the statement of the marks secured by the candidates who appeared in the OMR-based written examination. The marks pertain to the roll numbers, so and so, 7 roll numbers, including the petitioners, including that of the petitioner. Stop. This was sought for in pursuance to the earlier orders passed by the court. Mr. Bora, upon perusal of the said statement, it is seen that all the candidates bearing their respective roll numbers as shown in the statement were ultimately not selected. Stop. Petitioner was considered not qualified to apply for phase 2 examination, and accordingly he was also not selected. Stop. This court is of the view that this document ought to be brought on record by way of an affidavit. Mr. Bora is directed to file it within 2 weeks
Yes,
from today. List.
obliged, my lord.
Right.
Lordship has asked me to, my friend is appearing, Lordship.
Yes.
Mainly the last occasion, my lord, on High Order dated 8/9/2023. This honorable court directed wants to know what the institute taken response to the petitioner's application. That my lord, several application of first issue on first issues received from the applicant, my lord, and thereafter. Actually, we have no authority, we have no such scheme, my lord, because LGB Regional Institute of Mental Health, it is taken over from the government of Assam in the year 1999 by the government of India. We have no such scheme, my lord. Therefore, we have notified this notification, my lord. No, it is.
What is it about? Tell us. What is the scheme about?
My lord, after that, my lord, LGB is the registered under the society, under the Societies Registration Act, my lord. It has own constitution and rules, my lord. But feeling the hardship, my lord, feeling as the petitioner's financial hardship, my lord, we requested the contractors to absorb him. And he has been working under the contractors, my lord. My lord, the deputy director of the institute is present before your lordship, my lord. He may say, my lord. Mr. Deputy Director of.
We didn't call you. We didn't call you.
I have come to assist.
That's all right.
My lord,
Take your seat.
my lord, actually now the government of India insisted the institute to send some data to accommodate this person, those persons, my lord.
to adopt such.
You mean to
scheme.
say that there is a possibility of some scheme being
Yes, my lord. It is depend upon
considered
the,
on by the government of India? Very well, as and when it is done.
May I please your lordship?
But
But my friend that has placed before your lordship, initially this institution was run by the Government of Assam. And it is one of the oldest institutions of India. And we have already completed the centenary. But after this Assam government, matter was gone to the NEC, Northeastern Council. NEC has fully financed it and run the institution. Thereafter, Government of India adopted it as one of the National Institute for Mental Health.
regional.
Then, my lord, now it is under the complete under the Ministry of Health. Now, my lord, at present, to my information, about 80 employees are there
Hmm.
who are given the contractor. They are giving the money to the contractor, some crores of rupees yearly, and contractor is disbursing as per his own whims and decision, and no leave facilities, no medical facilities, no full-time work. They are asking. There is no system of
You take it up under the appropriate legislation.
no. There is no. They are not. No, if they assure us.
No,
that
no, there are
government
other
will take up the
legislation
matter.
which can redress your grievances.
Yes,
You are aware of that.
that's
If
true.
this
my
is the
lord.
issue about giving minimal wages, leave, etc. So
But
there are issues which
there
can be
is-
urged.
Above all,
Hmm.
there is no security of my job. I may be ousted tomorrow.
Yes, but this is an autonomous body.
Well, but earlier there the compassionate scheme was there on initially. That's why I asked them to. I have prayed before your lordship.
Earlier means,
No, memorandum of understanding that they've accepted from the Government of India, from the Government of Assam. That is there, everything, service conditions of all the employees.
no, correct. But will it ipso facto mean that the compassionate scheme framed by the government will be applicable? No.
Now, that today they are saying that it is not there. But they have, it is a fact that they have deputed us to work under contractor. And they are paying the entire money to the contractor.
So if you think that your claims and your dues under the contractor are not being paid,
Well, my
can
only
take it
prayer,
up.
Your Lordship,
You can take it
let
up.
there be security of my service.
no, that we can't
If they
order.
cannot assure me,
Your security for service will mean your entry has to be regular.
naturally it is there. I'm
How is
working
it
regularly.
regularized? Have
I'm
you,
very-
is it pursuant to, is it against a sanction post? It is pursuant to an advertisement, selection process.
That is very
Then-
requirement of law. But then instead of that, they have given it entrusted to the contractor.
Have you made the contractor a party?
I will wait, my lord. Let him
No,
assure
we are
me
not
that-
asking you to make, we are
Because
only
tomorrow-
asking you, has it been
my
made a
lord,
party?
tomorrow another contractor will come. He
Mr.
may ask me, my lord, that is the, what is my security, my lord? That's if I get any job.
First, you tell us whether you have is there a scheme for compassionate appointment being adopted by the institute?
My lord, we have come to
Is
know-
there any rule that you'd like to
No, madam.
place your reliance on?
we have come to know today that there is no compassion on scheme.
Then
We have come to know today.
how is it, what is your prayer here?
My letter for appointment on compassionate ground.
Then
Petitioner in the group D post in a regular post basis under the compassionate ground at Lokapura Gopinath Bordol regular.
one can understand that you are working or rendering service under the institute, on the payroll of the institute.
Yes, yes,
But you admit that you are under the payroll of some contractor.
yes, yes. Very true.
So therefore, how can your
But
services
my
rendered
name-
under a contractor?
My lord, my name have been recommended by my institution. That he is my employee. He asked you to-
Recommended where?
You put him in what?
Recommended where?
To serve under him. I have
Any-
been recruited by, I forwarded my name by the institution.
What is your name?
My name is Manoj Bodua. I want, my lord, any security of my life, my lord. Otherwise, tomorrow I will ousted, my lord.
You are asking for something which literally nobody can give you. Nobody can give to any of us.
No, my lord, if
How can there be?
if institute give me the appointment, then naturally I will, my service will be secured till my retirement.
No, you submitted security of life.
That is not, that is life is very difficult, my lord. Life by two, I mean employment, my lord.
If the government of India adopt this, now communication is going on, my lord, that the government of India insisting some data to fill up some post by compassionate. We shall forward the name of the petitioners. If he is.
No, have you
fulfill all
received,
the criteria.
is there any scheme? Is there any scheme now of the government of India?
They are bringing this scheme, my lord.
The
That's it.
scheme, my lord, but we have no authority, but because money has come.
Is there
from the-
any scheme at present?
No scheme, my lord, such compassionate appointment.
Hmm.
But they are going to adopt it, my lord.
So you are going to adopt some scheme of the government of India?
My lord, they are insisting that they will consider
Yes,
it.
Mr.
If they consider it.
I may be permitted to.
Yes,
to-
yes.
to check. So, actually, as per the compassionate scheme of the government of India, they are applicable to only central government. So, as this institute is an autonomous body, it was not automatically applicable to this institute. And the appointing, as per the scheme, the power for appointment is only given to the joint secretary and secretaries of the ministries. So recently, ministry is asking from us data regarding is there any applications or for under to be considered under compassionate appointment. So now we are assessing their eligibility, which is there is a 100 points scale as advised by the ministry. And if they are eligible, we will send it to the ministry because the director has no power to appoint any person under compensated ground. So once the eligibility is complete, then we'll send the list to the ministry. And if ministry desires, then he can be appointed. So at present, we do not have any power. We only have the provision that we'll send check the eligibility and send it to the ministry. And
In
and
their-
for the,
in that government of India, I will make a party. Let them appear and say.
Yeah.
I will make them party.
And for the time-
Kindly permit me to make them party.
You raise a plea that the government of India rules are applicable to autonomous bodies under the government of India. Is that a plea you are raising?
Give me some time.
You are asking the
No.
CGC to make a counter plea so that you can rely on his submissions.
My lord, since my learned friend is submitting that they have given a proposal.
Yes, who's appearing for CGC? Any CGC? Yes, madam.
My lord, CGC,
You are a
He
CGC.
is also CG.
Oh,
my lord, government of India's
Yes.
scheme is there, my lord.
Lord, it
It
is
is a
clearly
appli-
mentioning that it is for central government. So it does not automatically applicable to autonomous bodies.
automatically applicable.
It does not automatically applicable.
You show it to Mr.
Yeah,
Biswas.
it is
Give
clearly
to him.
written that it is.
Let him go through
This
it.
is for central government employees, and it is clearly mentioned who can appoint. And for the time being, actually, as the opposite learned council has stated, for the time being, on an sympathy ground, we have asked that the applicant to be engaged by the contractor on the daily wage basis. And this is only the sympathy ground we are doing because we do not have power to appoint him.
Extend your sympathy in a better way.
All right.
No,
Heard
we do not have power.
learned counsels for the parties. Mr. Dr. Learned CGC and counsel appearing for the respondents submits that there is no proposal for compassionate appointment scheme. There is no compassionate appointment scheme at present, followed by the institute. However, there is a there is some query being raised at the competent department in the central government to examine the cases of persons like the petitioner, whether they can be accommodated on compassionate scheme, which is ordinarily followed by the central government. Stop. In this context, information from the institute has been called for by the department and the same are in the process of being transmitted. Stop. It is submitted that in the event there is a decision at the competent level at the central government that the compassionate appointment schemes which are followed in the central government by the central government would be applicable to the institute, then the case of the petitioner and other similarly situated persons will be considered. Mr. Biswas, Learned Counsel for the petitioner, submits that a direction be issued to the respondents to consider his claim for compassionate appointment. He, however, craves leave of the court to examine the proposals stated to be under consideration at the competent department in the central government. The matter, he prays that the matter be deferred and be listed after 2 weeks.
4 weeks.
4 weeks, all right. Accordingly, matter be listed after 4 weeks. Mr.
Dr. H. Dr. Hemanta Datta. Dr. Hemanta Datta.
Dr. Hemanta Datta. Who are you?
Deputy Director.
Deputy Director of the Institute is also present in court. Matter stands adjourned for 4 weeks.
I'm also standing counsel of the institute, my lord.
No, that is okay, but
Last occasion.
does it reflect a view that tomorrow if the central government says no, you will say no?
No, my lord, I'm a central government as well as the.
No,
standing
that's all
counsel.
right, but both are separate institutes. You dwell over whether you'd like to appear for both the institutes at the same time or
কি problem?
Like,
May I please? This petition has been preferred by the petitioner for a direction that because his case was not considered for promotion to the post of superintendent food and civil supplies and consumer affairs, but his juniors were promoted to the post with effect from 7/3/2019. So this petition is preferred that his promotion may also be considered from 7/3/2019. Lordship, may I?
My lord, I have just placed a gradation list. The last occasion there was a query about it, my lord. And my lord will find in the third page, in serial number 22, the petitioner Ravindra Deka, he was given a promoted to superintendent extreme right hand side, my lord, from 7/11/2020. He was given a promotion, my lord. So, my lord, this is now the gradation list as of today, my lord. So, my humble submission would be
Ravindra Deka's name is 20.
in 22.
he wants promotion from 19. You want promotion from when?
I want promotion from 19, but
19.
I was promoted from 20.
You want promotion from the date when the respondents were promoted,
Yes, madam. That time.
which
my-
according to you, you are senior in the gradation list. You are
I am
senior.
senior in the gradation. I am showing my form.
Yes, why was he not considered for promotion that time?
That is the issue.
Any pleadings, any affidavit filed
My
by
lord,
respondents?
respondent has not filed any
Then-
affidavit.
Mr. Dhor,
My lord,
why have you not filed any affidavit? Why his case was overlooked?
that my lord, I have to find out, my lord.
That is the core issue.
My lord. But now that I understand, my lord, I'll have to bring on record, my lord, why his thing
You
was
give
not
us the
considered.
DPC, we can find out. The
If
DPC
there was a
minutes,
DP or something, maybe I
DPC
don't know.
minutes, DPC minutes along with the agenda will reveal why he was not considered.
My lord.
My lord, I have filed an additional.
no,
with your lordship.
in-
Kindly pay
In
with that.
DPC, my lord, if he was not, my lord, his name was not sent, then he was not under zone of, he was not in zone of consideration.
Therefore, the DPC agenda. Agenda
Yes.
which was placed before the DPC will reflect how many people were there, whose name was sent.
Why he has not promoted?
My lord.
The reasons must be reflected in the.
Yes, you are referring to some affidavit.
Affidavit.
Yes.
This affidavit reflects that some departmental DPC was pending, my lord.
If
Some-
it was pending, then
He was totally exonerated. It is page 14, my lord. Whereas a departmental proceeding was drawn against Ravindra Deka on 8/10/2014, and now after last paragraph, my lord, now after careful consideration of facts and circumstances mentioned above, and having regard to the findings of the inquiry officer Assam, during the inquiry matter, the governor was pleased to conclude the department against the
Sorry, you are reading from page number
44, my lords, running
44.
page, and individual page is 14.
Yeah.
Running page it is 44.
Yes, 44, yes.
Yes.
addition.
By exonerating last para, my lord, last line, my lord, by exonerating him from charges level against him by so cause notice dated also. So he was.
So he was put under seal cover.
It ought to have been put under seal cover, but they were not equipped at each other. My promotion has not been considered. That is the case, my lord. Lordship may kindly see the another letter, my lord. As page 46, my lord. He has retrospective promotion was given to him, my lord,
Hmm.
from 7/11/2020, not from the 2019, my lord. Lordship may kindly 46, my lord.
Hmm.
He was retrospectively promoted subsequently, my lord, but not from the date of his juniors.
Therefore, whether you are at all sent for consideration, and if not, why not? That information.
If the departmental proceeding is for pending, my lord.
Yes, Mr.
My lord,
Dhor.
Well.
You give us the records. That will, your affidavit will take not less than 6 months. You get the records at least.
well, I will get the DPC record. That
We-
will
Hmm?
be more clear, my lord. If the record is before your lordship, it
Yes,
will be easier.
the records why his case was not considered in the DPC along with the private respondents. It is possible that he may not have come. There was some inquiry.
Yes, my lord.
So all these issues will be there.
And if there is any error apparent in on the respondent, it has to be, my lord, taken into consideration.
Hmm.
He should get them.
Yes. When can you get it?
Lord. My lord, next week, next Friday, or
Next Friday.
My lord, I have a prayer. Let the matter be listed between 9 and 19, my lord. The next 2 weeks, I will be outside the headquarters for my personal work.
All right, let it be on
9 to 19, any day, my lord. Court is open.
10th. 10th.
10th.
Let it be on 10th.
Oblige.
Mr. Pegu, who's appearing for the respondents?
I am for the, my lord, private respondents, my lord.
Paying.
Yes,
Yes. What are you doing? Appearing for?
I'm appearing for, my lord, the respondent. my lord.
Your promotion has not been
No,
regularized.
no.
You are
My
agreed by
promotion-
that.
My lord, what happened, my lord? Problem is-
Now, what is the fun in keeping him suspended? You already got promotion.
So far, his case, my lord,
Hmm.
he may be released from the interim.
That's what. So
My prayer is that must time to be
there's
released.
some vacating petition you filed.
Yes, my lord.
A vacating petition put you.
Yes, that,
The other two may be.
that may be kept pending. I have no problem on that.
He may be released. So far, he may be, he is concerned, the interim order may be relaxed. my.
Yes. Heard Mr. J. Paying, learned count. This is in IA 2169. Mr. J. Paying. for the applicant who are the private respondents number
My lord, respondent number 5 and 6. my lord.
5 and 6 in
So
WPC
far it is 5, my lord.
1760
6, there is a difficulty, my lord.
2016. Why?
My lord, he is saying that his date of retirement is only 6. My lordship may kindly see the date of retirement of this person, my lord. Ranjit Bhattacharya, SPS 20.
Hmm.
His date of birth is 1164. My. I am also retiring on the 19 the coming year, my lord. He will retire on January, my lord.
No, he's retiring on
January, my. So,
31/12. 31/12.
31/12, my lord. He is retiring on 31/12.
So where is the problem?
Now, his case is not problem, my lord. He is Ajit Putum. Ajit Putum is retiring on 31/2025, my lord. So his case, he should not be released.
Why? How does it affect you? You are promoted.
No, that
You are
will affect
promoted.
the
Your
gradation list.
gradation list, your position in the gradation list is subject to the finding of this court in respect of
My lord,
as
that
to
will be
why.
clarified.
Of course, it has to be.
That may be clarified. my lord.
Yes, heard so and so learned counsels for the petitioner. This IA, Mr. Dhor for the respondent department. Anyone else appearing? Mr. TJ Mohanto, assisted by learned counsel so and so appearing for respondent 4. Mr. There is no respondent 7. In the IA, we're talking about IA.
IA is not there. IA is not there.
This IA has been filed by the petitioner seeking vacation of the order dated 29/03/2019 passed by this court in WPC 1760 of 2019. Stop. By the said order, the following directions was issued. Quote the order, page number 14. As a consequence of the said order, the applicants who were respondents, private respondents in the writ petition, came to be promoted to the next higher post of superintendent. However, their what is that? Regularization. Regularization has not been granted by the department in view of the interim order passed. Stop. Being aggrieved, he has filed the present writ petition. IA. Para. During the course of the hearing, it was pointed out by the learned counsel appearing for the department that in the meantime, the opposite party, namely so-and-so, who is the writ petitioner in WPC so-and-so, was also promoted to the post of superintendent with effect from 19/8/2021. Stop. At present, both the applicants as well as the writ petitioner have been promoted to the post of superintendent. Stop. Under such circumstances, the only question that is to be answered in the writ petition now you write para in the writ petition, the opposite party number
We were 5 and 6, man.
opposite party number 1, who is the writ petitioner, made the following prayers, page number 8 of the writ petition. Out of these prayers, prayer number 6 stood withdrawn, as is reflected in the order dated 29/5/2019. Stop. Consequently, only prayer number A and B are required to be dealt with. Stop. However, in view of the order, in view of the information furnished before the court by the learned government advocate, which reflects that the petitioner in the meantime has also been promoted to the post of superintendent with effect from so and so date, 2021.
is earlier, it is wrongly stated. It is retrospectively.
The only question that needs to be answered is the claim of the petitioner for promotion to the post of superintendent with effect from the date the applicants stood promoted, which is
7/3/19.
2019. Stop. The grievance of the writ petitioner / private respondent number, opposite party number 1, was that he was senior to the applicants in the feeder category, which is the post of UDA.
No, my lord, it is a.
Inspector one.
Inspector. In that view of the matter, the only grievance which is required to be answered in the writ petition is the claim of the petitioner with effect, the claim of the petitioner to have been promoted, the claim of the petitioner for retrospective benefit with effect from the date of his juniors were promoted, which is 7/3/2019. Stop. Under such circumstances, this court is of the view that this issue can be redressed. This issue will be decided in the writ petition, and for which purpose the necessary orders to be passed in respect of the applicants for regularization need not be kept pending or suspended. Stop. The petitioner, as discussed above, as the petitioner has been promoted with effect from so and so date to the post of superintendent, the only question would be his position in the gradation list vis-a-vis the seniority of the applicants, which issue can be decided in the writ petition. And the same will not, and the vacation or modification of the order dated so and so will not come in the way of deciding the said issue. Accordingly, this I stands allowed. Interim order dated so and so stands vacated. The respondents' cases for consideration may be proceeded with by the department. I stands allowed and disposed of. And then, insofar as the writ petition WPC 1760, Mr. Dhor submits that he would like to produce the relevant records in the matter, which will reflect as to why the case of the petitioner was not considered by the DPC at the relevant point in time, along with the private respondents number 5 and 6. Writ petition respondent number 5 and 6.
Yes, madam.
5 and 6. Stop. The the claim of the petitioner is that his case was overlooked without any reason. Therefore, his claim for seniority above the respondent number 5 and 6 is required to be answered by this court. Mr. Kolita appearing for?
That's not 7.
Mr. Kolita appears for 7.
In IL also, I am for-
Mr. TJ Monto, assisted by Mr. So-and-so, appears for respondent number 4. Mr. Bhattacharya for petitioner.
Petition, I am respondent number 4 and I am respondent.
Right. Petition 4, respondent number IA 5. Matter
IA
be placed for admission hearing on.
10th.
You wanted some date, na? 10th
10th.
October.
In IA, I am for response 6.
My lord, I'm giving the IA who are the parties there in the IA. I probably.
You give it in a cheat to the court master.
Yes.
Based on 10th.
Mayor, please allow. Also, in this case,
Yes,
the responsible 7 has filed an affidavit on 30 August. Also, I pray for 4 weeks time to file reply. 30 August 2020.
Mr. S.K. Das, learned counsel for the petitioner, prays for 4 weeks' time as he submits that he'd like to file a rejoinder to the affidavit filed by
The responsible 7.
respondent number 7. Prayer is not objected to by learned counsel appearing for Mr. Monto, you're appearing for
Responsible 7.
7.
Respond number 7, madam. Actually, my
Mr.
lord,
Bora for
2 to 6.
2 to 6. You're for 1. Mr. Dotto for 1. Yes, Dotto for 1.
Lordship, the interim order can be.
Matter be listed after 4 weeks.
finally, my lord, that may be fixed, my lord, because here in this case, my lord, only names, my lord, are made. That only my names difference, my lord. He says that he's my, it is there in one select list, his name is
Give a
there,
date,
in another
give a
select,
date
my
after
is
4
there.
weeks.
And because of this stay order,
Interim
my lord,
order
the others are appointed. I
continued.
am going to turn on.
Obliged.
6th of November.
Obliged.
Seven, my lord, BTC has a specific rule. And there was no clarity as regards rules to file affidavit. Some instructions sent to us. BTC has to file. I had informed Mr. Nayak.
Who's appearing for BPC?
Informed Mr. Nayak also, Mr. Abha also. I was informed that Mr.
They're not filing.
I'm not filing anything. I will hand over my instructions to them. Because these persons who are seeking this regulation, they are not in a regular employment. They have already left.
What do you say, Mr. Counsel?
Next payment will be next check.
Hmm?
The
Six,
concerned
next
counsel
week.
is not present actually.
I can't.
I'm not the engaged counsel.
You are not the engaged counsel. Who is the engaged counsel?
AK Maheswari.
AK?
Maheswari.
Right.
He's out of station.
Your name, please?
Ravi Sharma.
Mr. Ravi Sharma, learned counsel, appearing on behalf of Mr. A.K. Maheshwari, submits that the matters be adjourned as Mr. Maheshwari is out of station.
Well,
Mr. Gogoi, learned standing counsel, appears for the forest. None appears for
Alright.
BTC. Matter stands adjourned for 4 weeks.
Date
4
may be
weeks.
given.
4 weeks.
Date may be given.
Date
After Puja, it will.
this year or next year? 6th of November. 6th of November.
Obliged.
Yes, Mr. Borbora.
It's a peculiar matter. Actually, I am basically, my lord, postgraduate psychiatric nurse, working since, my lord, 2005 at the LGB Regional Institute of Mental Health. My lord, what happened? On declaration of, my lord, the total lockdown during the coronavirus lockdown, my lord, an office memorandum was issued by central government, which your lordship will find at page 28 of the petition.
Yes.
So it says, HODs may ensure 50% of Group B and Group C, we are C, my lord, required to attend office every day, and remaining 50% staff should be instructed to work from home.
Mhm.
All HODs are advised to draft a weekly roster duty for Group BC and ask them to attend office alternate weeks. Then below, my lord, Roman 3, officials who are working from home on a particular day as per roster will be available on telephone and electronic means of communication at all times. They should attend office if called for by any exigency of work. That was the lockdown situation. My lord, on 20, I continued, my lord, my regular duty on till 24th of March. 20th of March, my lord, the lockdown for 3 weeks, total lockdown was announced, as you lord aware. I was informed by the my lord ward in charge telephonically to avail my lord special off from 26th for a week. I mean, my lord, being an out-campus employee, my lord, and my house at a distance, I had to travel a few kilometers from my home to the hospital campus. In normal time, my lord, it was no problem. I was doing that, but in COVID total pandemic, no public transport was available. And my lord, sometimes my husband drops me, and my lord, without a pass, my lord, even he couldn't drop me. Therefore, by page 37 email, I requested the authorities to provide a car pass to my husband. Page 37 email. And that was not given, my lord. Then this is the mail, my lord, at page 37, application for issue of a pass for vehicle. So that was not given. Ultimately, it was given on 6th of April. As a result, from 2nd of April to 5th, my lord, I couldn't attend my duties. And then, my lord, I was served with a notice show cause, which your lordship will find at page 35. Because the email, my lord, having not get the pass copy, I wrote to the director, my lord, sent a copy to the director and one to the ministry, because this is under central government. And they found fault on that and gives this memorandum, absent unauthorizedly with effect from 26 to 5th, for about, my lord, 8-9 days, persuading one or others. Then secondly, Rule 20 CCS, my lord, conduct rules, it said that it was my fault, my lord, in directly giving a copy to the Union Ministry, my lord, which, my lord, actually Rule 20, my lord, the ingredients are not here. It is about political influence. So therefore, I replied, my lord, denying the allegations that and the circumstances for my absence, and that telephonically, actually, my lord, the chief matron allowed me leave on those days. However, my lord, I was again, my lord, served with a notice at page 48. And surprisingly, my lord, I was shocked to find a manipulation of the copy of the duty register, annexed as document number 4 with the charge sheet, which your lordship will find at page 57. I'm not reading the article. They reiterated the article. This is the second notice. My lord, page 37, the relevant page is 57. So this is the Xerox copy as was communicated to me. That chart, my lord, page 57. My name is top, my lord, Biola Borua. Lordship will kindly see there are sketches and, my lord, overwriting and, my lord, manipulation in the duty register, which is in the custody of, my lord, the superior officer, not me. I cannot be the custodian. I don't make entries here, my lord. Here, my lord, kindly see, against all other nurses, there is no erased marks or scratch throws, etc. Only against my name, and for those particular 7-8 days, 26 to 5th of April, 26 March, I think it was sought to be written as A or M, I don't know. So this is what I got. Then, my lord, this overwritten, my lord, blackish page is also annexed by the respondent's affidavit, which your lordship will find. The affidavit, my lord, filed by the respondent authorities, my lord, my authorities. They are at page 13, lordship. This is affidavit dated.
What is your prayer in the writ petition? You are
My
challenging.
lord, I challenge the proceeding because, my lord, this was by the custodian of the duty register. So this is, my lord, basically a very peculiar, my lord, manipulation. And I have been thought
Your
to be,
prayers do not reflect it.
no, my lord, I have made it two things. And the custodian has been made the, my lord, presenting officer.
But now,
That I challenge. And
now-
officer, they had now
now
been
he's
changed.
retired.
No, but for adjudication, my lord, my Ghost title lordship.
Now
as
matter
expected.
become infrastructure.
No. I'll show. I have got something to say. Page 3, my lord.
He used the custodian.
Yes, page 3. Definitely, I'll cross-examine. The administrative officer and the custodian of this and the chief matron.
Page
executive.
3 of the writ petition.
3, my lord, impugned memorandum containing article of charges, my lord, whereby the disciplinary proceeding was initiated. Now, my lord, the question is, so I have challenged the proceeding this way, and in paragraph.
No,
also-
but have you seen this letter?
Yes.
Have you seen this letter? There is a letter
That
furnished
that
by
was given, my lord,
on
my lord.
8th of September.
Yes, lordship, there before 16th of August, there was an order, lordship may see. This court, my lord, called for the original of that page
Hmm.
of the duty register.
Hmm.
Original of that. Here, my lord. Because I have been supplied with a Xerox copy which contained, my lord, this.
No, that's quite all right. What we are saying is that the DP has not yet proceeded. Your grievance is that the custodian of the records
Yes.
has been made the presenting officer.
Yes.
This gentleman apparently is retired. Now another gentleman has come in.
So now, my lord, this was.
Now,
this
if you have to challenge the DP itself, that's a different issue.
I'm challenging.
But if you are challenging the appointment of the presenting officer, then perhaps your prayer has been answered by flux of time.
That part has been done away.
Right.
That part has been done away. And my lord, now the presenting officer, who is the presenting officer, the nephew of the my lord, I will not go into that. He too may be biased. The last order, as per last order, this my lord is case copy, this page particular, page 13, the original was called for by your lord. The order is there, my lord. 16.8, referring, heard so and so, referring affidavit on opposition 5 by the respondent, page 13. Senior counsel submits that the original record be called for. In view of above, counsel for the respondent who is directed to produce the original record of the attendance register on next date. Now, so now original is being here, and I am being called for. There, this original record is the crux of the matter. Things cannot proceed there, and I have been called for, my lord, appearing on my lord tomorrow by this letter.
Tomorrow.
Tomorrow I have been called. So, Lord,
So these records will go today. These records will go today.
Today,
It will
my
be available
officer is-
tomorrow
also
before
my
the
officer
inquiry
is here.
officer.
He is here. He is here.
but Lordship will have to adjudicate the, my lord, the
Otherwise,
proceeding, my lord, on the face of it.
otherwise the
Proceeding
issue,
on the face of it, and there is also allegation that I sent a copy of my email, therefore another article was put on me under Rule 20. Prima facie, my lord, the Rule 20 of the service rule does
No,
not apply.
you
is
want
also a
us,
metaphor.
you want us to interfere with the very process of initiating a departmental proceeding,
Yes.
isn't it?
On the face of the, my lord, memorandum of charges.
On the, where are the memorandum of charges?
My lord, I have referred to, my lord. Both the charges are, my lord, both the charges are, my lord, prima facie, my lord. Please, my lord, page 35. Definitely, court can under 226 also, when I make it impugned, my lord,
35.
the memorandum initiating the proceeding, I have impugned. And there are cases, my lord, where proceedings have been set aside. Number 1, absent unauthorized. So this is also fishy, my lord. Prima facie on the face of the, my lord, that page for the relevant date. This is tempered. This is tempered. I am not the custodian of this. How could this happen? Lordship may definitely Lordship will be called upon. And then kindly see whether 20 is attracted. When repeatedly you didn't give any corpus to me, as a result of which I couldn't attend, my lord, for those days, and the matron, my lord, allowed telephonically. The original SOP circular, my lord, I have shown that during that total lockdown period, I could communicate with my immediate next step of, my lord, which is the chief matron. And she allowed me to leave. And they have shown me unauthorized. Now 20, my lord, Rule 20 is here. Canvassing of non-official or other outside influence. Rule
This
20.
is CCS,
Yes.
CCS.
Yes. It is a different thing. CCS rule. Can we have a look?
TCS conduct.
I am charged under that. This is the first charge is this.
Page number?
In this book, my lord, page number 183. Both. The very basis of my lord initiation of proceeding, I am challenging. It is malicious, my lord. It is tempered. And so far as the second charge is concerned, email directly, actually not directly, I have sent the mail. I have shown, my lord, copy sent. 20, it says, my lord, canvassing of non-official or other outside influence. No government servant shall bring or attempt to bring any political or other outside influence to bear upon any superior authority to further his interest in respect of matters pertaining to his service under government. Does it apply, my lord? Prima facie. See the email? I was, my lord, repeatedly I was asking for a car pass. And you victimize a nurse. And I have also annexed. The scratch annexer also, my lord, does not tally totally because on 2 dates, my lord, I was given off duty, service off. Email is at page 40. No, kindly see. This is the email. It starts from, my lord, several emails. It starts from, my lord, page 37 is an application form. I mailed it. Page 37 to the director. Then again, my lord, another one. At page 38, page 39. Application for arrangement of transportation pass or grant leave. District, regarding my vehicle pass, I had already contacted district administration, but they said it is the matter of the hospital. Now I am, what I am supposed to do? Hospital authority advised me to contact district administration. So this email, my lord, next page, lordship, kindly turn to page 40. I sent a copy to the Ministry of Health because this is an institution under the statewide under the Ministry of Health. So is it a crime or is it a misconduct, my lord? Is it, my lord, a politically influencing attempt? Or does it prima facie attract charge number 2? That is, my lord, precisely the question in this case.
For what purpose you referred the email to the in a union ministry?
Nobody, my lord, responded. Nobody provided me even a car pass, my lord. And this is nothing really bars, my lord. I have simply sent a copy. I approached the deputy commissioner of the district. He said, no, it is not my. So, then I have read, my lord, 20. Conduct rule. 20, my lord, no ingredients of 20 is here. It is not canvassing. It is not political or outside influence.
It is an email to a political representative.
No, my lord, he is an official minister, man.
Whatever.
Public service.
Official, your head of the department is the secretary.
Director, I have, my lord, consistently.
No, head of the department is not the minister. It is the secretary. So you have not addressed the email to the secretary.
My lord, I have sent it to the government of India.
You have sent it to
No,
the.
no, lordship, may kindly say, not minister, Ministry of Health and Family Welfare. Kindly read.
Page number
40.
40.
Not minister, Mr. So-and-so. Ministry of Health and Family Welfare. How can it, my lord? Can I not, my lord? When the director, the chief of the institution doesn't care for, when the district magistrate, my lord, deputy commissioner doesn't care for, in all earnestness, my lord, and as a dutiful nurse, my lord, I had to do it, my lord. I am a postgraduate. Promoted to, my lord, tutor. So this doesn't attract.
Is there any email you have sent directly?
No. No. This is what they are finding fault with.
Yes, Mr. Gogoi.
My lord, may kindly come to page 22 of the requisition also.
22.
22.
Yes.
This is the pair made by the petitioner.
Yes,
That
they
we
are-
have already pointed out.
The basic
So
pair
there
is
is, there is
No, I have
strictly,
said, or
there's
for, or my lord,
there is strictly no bar
Lordship.
to say that we cannot
Other
look into the aspect of the correctness of the proceeding itself.
Lordship.
issue is
But
urgent.
yes, technically speaking, he was aggrieved by this letter.
That was already done. So,
Hmm.
Lordship, on the face of the report, Lordship, the matter become impactual. Otherwise, the preliminary stage, Lordship, she can reply, she can participate.
She has already
Ah,
replied. Now
she
the
may-
question
she may-
is,
She may participate the proceeding, Lordship.
no, she can
She-
participate,
Lordship.
she
That
will
is known to
participate, but
everybody.
And Lordship, now under 226 jurisdiction, the departmental posting the initial stage, Lordship, whether Lordship can interfere. it or
is
not.
for you to address, you
Lordship.
address us on this,
Lordship,
whether we
as
can or
per
we
the-
cannot.
As per the petition filed by the petitioner, Lordship,
Hmm.
the pair made only in respect of the Lordship, sense of the presenting officer, Lordship.
Or
That
any
was-
other, my lord, I have, or any, like every petitioner, my lord, the
And that
surgery
part is,
or any other order as your lordship may deem fit and proper, it is always written. Here also it is written. And in the cause title, I have clearly said that it is impugned. And in one paragraph also I have said that it is impugned. Paragraph 25. Petitioner begs to state that the aforesaid impugned action of the official
the
respondents,
authority of the
one
presenting
minute,
officer
in
till today
contemplating-
not attain any finality, Lordship.
page 25, my lord. Paragraph 25 of the writ petition 19, here also I have challenged. In contemplating to proceed with the proposed inquiry against the petitioner in the manner described herein before has been done for extraneous consideration and as such is impugned action. Action means action of initiating proceeding by that impugned article is liable to be declared. It is here in the pleadings.
Nothing is there, Lordship, regarding that particular charge sheet, Lordship. No way it was challenged, Lord.
Paragraph 27 and then page 3 of the cost title, impugned memorandum.
Their
That
basic
means
grievance,
impugned memorandum in initiating the
their
proceeding.
basic grievances, Lordship, against the presenting officer. Today also, we, Lordship, the presenting officer, as because, Lordship, that particular person was, Lordship, retired, so it was changed, Lordship. Otherwise also, if the person is not retired, then we have to defend the case, our case also, Lordship. We have filed affidavit. As because the person is no longer in the service, Lordship, so we have changed the presenting officer, Lordship. The grievances, Lordship, as per the petition which was made by the petitioner is fulfilled, Lordship.
Yes, 1, 2, 3 given.
Lordship.
Inquiry officer changed, presenting officer changed, but challenge to the proceeding remains.
If
That's
it
my
challenge a particular proceeding, it should be, Lordship, directly mentioned there. That format will not do, Lordship.
Now,
format.
Mr. Borbora, assuming we hold that Rule 20, etc., are not applicable in your case, but the question of unauthorized or absence or not is a matter of fact.
But this is that, therefore, my lord, this court, my lord, asked him to
We-
produce the records.
No,
If your lordship finds.
no,
that
correct,
yes,
correct,
it is
correct,
not were written,
correct.
then your lordship will definitely make an
That
observation.
will require, we may make an observation, but that observation, you see, unless we take it on ourselves to come to a finding that this is not unauthorized absence, that will require evidence.
No, lordship may.
That will require
find- no,
evidence.
Lordship may find one thing.
That will require evidence as to
That's
who,
different.
who
If
was
we-
responsible for striking out.
My lord, if the original also, your lordship finds,
So we'll find out, assuming it is,
then my lord, lordship will definitely have some prima facie satisfaction.
No,
that
but
yes,
prima
how
facie,
can- how can
prima
we
facie
not-
satisfaction is not sufficient to interfere with a DP.
My lordship will have a look. How come you, the custodian, and in your custody,
Instead,
this has happened?
instead,
That is,
no, instead, since you have already filed the reply and the officer has already been changed, let the proceeding, you participate in the proceeding.
I'm telling
We are still here in case you are aggrieved. For all you know, the charges may be dropped against you
My lord, there are.
unless you are alleging malice against the presiding inquiry officer, presenting officer.
Entire, my lord, memorandum of charge, initiation of proceeding was malicious.
Against whom?
That is against me,
By whom?
by the, my lord, appointing authority.
So then you have to array them as parties.
He is, my lord. He is the appointing authority, person who issues the search sheet,
Where is he?
director.
No, by name.
No,
You
no,
have to array him by name. You're
no, my
making
lord,
an
the
allegation.
HOD and
No,
administrative
no,
officer.
no, by name.
No, by authority, my lord, is, I think.
No, by name, Mr. Borbora, you know malice. You are alleging malice. That gentleman or the person will have to be given an opportunity.
No, my lord,
The same yardstick that you are now urging,
no, my lord, that is for contempt.
not for contempt.
No, my lord, the malice, if it is by the authority, if it is by the authority.
Unless you say
And a
that there is a
particular-
legal malice.
The authority himself is the authority, my lord. Respondent three is the authority.
No,
Respondent
but how do you bring home the charge of legal malice or personal bias in respect of clause number 1 of the OM, where it
Number
says
one is-
unauthorized?
One thing is, there are two things. One thing, section, prima facie section. Rule.
Let us prima facie give you the benefit section, rule 20 not applicable.
Not
What about the clause 1, the first charge,
First charge, my lord.
unauthorized absence?
First charge, my lord, unauthorized absent part. First charge, my lord, the record, the very record, my lord, reflecting.
All right, we give it to you that it was struck off.
If in the original,
We have not looked, but let us say it is there. It was struck off. What is the interpretation of that?
then manipulation
By whom?
by the custodian,
Who is the custodian?
my lord, HOD and the administrative officer.
So you have to array them as parties.
I
You're
have
making
my-
a personal allegation.
Respondent 3 and 4.
No.
They are issuing
Mr.
only serious charge sheet.
Borbora, you're such a seasoned counsel.
No,
Know that. You're making an allegation of interpolation.
It is legally, it is an action arbitrary, it is malicious, my lord, it is, my lord.
So
ingredient of the rules,
therefore,
my-
should the court not give an opportunity to the person concerned? You have to array them as parties. If you insist that yes, we are alleging
My lord,
malice.
in writ petition, contempt is defined. In writ petition, my lord, I sincerely believe, my lord, subject to correction, if by designation the authority, I say that this particular authority, general manager was acting
Which
malicious.
general manager, whether that person was still there, who's not there,
That they will have to say.
then you are an employee, you know,
no, I
you're
don't-
making an allegation.
My lord, I don't go by the date of
Mr.
retirement.
Mr. Borbora, you can't make an allegation that it is in the custody. It is like this.
It is-
There is some interpolation in the records of particular office. You may make an allegation against the head of the office. Technically, the head of the office is responsible for safe custody. But there may be other officers down below who could actually be in the safe custody, responsible for the safe custody.
But I am victimized.
You are victimized, therefore,
I am victimized.
no, you are,
I know about my victimization, my lord. In between, there was a third person and he did it. I cannot explain it.
no. These, are these the grounds you have taken up on the reply? Where is your reply?
Everywhere, my lord. Everywhere, from the right from the
Where is your
first
reply?
reply. My lord, page 61, written statement, page 61. Page 61, first sentence. Moreover, the copy of the duty register supplied by the authority to me appears to have been manipulated and tampered with in view of the fact that the relevant dates where I have been marked absent clearly bear signs of overwriting. Furthermore, I vehemently deny that I was assigned duty during the period in question and that no service of was granted. I deny. It appears from the aforesaid duty register that it was only against my name that such tampering and overwriting is visible concerning the relevant date. Only against my name, not against any of the other.
So who was the custodian there? Who was the custodian of these records?
My lord, the HOD. and
Who is the
administrative officer. Immediately administrative officer and my lord HOD.
Then you'll have
The
to array
office
them.
memorandum, my lord, the
No,
office.
then you'll have to array them as parties.
My lord, HOD, I have a
No, by name.
name, my lord, that my lord. Frankly speaking, I have not.
Huh?
By authority. Name, I have not erected.
I know. Therefore, you have to array them because you'll have to issue notice.
For the purpose of malice.
Yes.
Suppose minus malice.
Then
Is it necessary?
no.
Minus malice.
Malice is what you have alleged.
Prima facie,
If you take away malice, then it is your statement versus the department for which the proceeding has been initiated. Now you don't want to participate in the proceeding. You want us
Yes.
to give a finding.
Yes.
To which the question,
That was
the
the
query
number
of the
one.
court would be, why should we, when the proceeding has
That
been
was the
initiated?
number one. That was the number one.
No, if
And
there is
number-
a proceeding initiated, you have participated by giving a written statement. You have given a written statement. This is the written statement.
The first denial I will have to give.
Yes.
Yes.
Now, which means you have participated in the proceeding.
The question is,
Now, unless you make out a strong case of malice or bias against the authorities initiating disciplinary proceeding, why should we exercise our
no,
jurisdiction?
my lord, one thing. The moment I was given the written statement, I'm sorry, the memorandum of charges accompanying this document, I replied. After my lord, my written statement, two things could have happened. On being satisfied, they could have passed it on. On being dissatisfied, they will call me for the inquiry. Two things. I am at the very first stage.
Very good, then we'll hear it if that is what you want.
This will be a good, but for the time being, my lord, that since this recording will be the crux, my lord. Time being, my lord, let them.
We'll set it up for hearing on some other date.
Yes, my lord. Time being, but tomorrow they are calling me. Let them, my lord, wait for a few days.
Hard Learned Counsel, Senior Mr. A.C. Borpura, Learned Senior Counsel, assisted by Ms. So-and-so, Mr. K. Gogoi, Mr. You're appearing for all. It is
And
submitted.
also,
that is-
I'll, my lord, sir, I'm sorry, my lord. Whether it is necessary to impede by name when I eliminate.
Subject to correction, prima facie, I feel,
My lord, your lordship may be correct. Let me also try. My lord.
yes.
On the next
Matter be posted for hearing in the first week of November.
Meanwhile, this letter, my lord, by this letter, they are asking me to appear tomorrow before the inquiry.
You don't proceed with the inquiry now because we are hearing the matter.
Both cannot go.
Initial letter also honorable court did not stay the proceeding.
May not be, but we need not stay provided you agree not to proceed. If you agree not to proceed,
Actually, her grievance is already.
all right,
Al-
till the
al-
next
already
date, further
proceed.
proceedings in so and so remains state. No further proceeding in the DP.
Disciplinary proceeding.
Lordship may
Disciplinary
no need to indicate it, we will not proceed.
No, my lord.
Even lordship the first, for that lordship, you have to file a petition.
When lordship may record his.
We are making it easier for you. We are passing the order. Don't proceed.
Lordship may fix it for final hearing, final consent. Otherwise, it was delay lordship. It is a,
Yeah,
it
final
is
hearing,
case
give a
lordship,
date, November.
it is a delay lordship otherwise.
November.
Delay tactics, nothing is there lordship. Even lordship, no was
9 November.
nine. Before that lordship, before vacation lordship.
No, not before.
It will be lordship,
9 November.
it will be too late before vacation. I will try, we will try lordship.
What will be too late?
Lordship,
They are suffering.
already lordship.
I cannot escape, my lord.
Already
Question is,
lordship that 2
I-
years is gone lordship.
I have 20
More
years to
than, more
retire.
than 2 years is gone lordship.
I
already.
have
Lordship
to-
may put it before vacation, we will try lordship.
Before vacation, we don't
lordship-
know. We cannot guarantee you because
Lordship may put it
there are,
before
the
vacation, we will
dockets are
try
full.
lordship.
The dockets are full, Mr.
Lordship. No, lordship may fix it. If not possible, then lordship may defer it lordship.
Immediately after vacation.
Lordship.
It will require some, my lord, length of argument.
It is not required, almost lordship had hard it lordship.
All right, 12th October.
12 lordship. Yeah.
12th October.
Lordship.
12th October will be last day, I believe.
No lordship, it is, no.
All right, my lord, if it cannot be, if it doesn't reach, my lord, I will.
Vacation only starts from 23rd lordship.
If it is not finished, my lord, today's order will,
Till 12th October. Yes.
till then, lordship may observe. All right.
allowed to mention anything. Hearing item 19, my lord. Other side is absent, he informed me over phone. But matter is urgent relating to pension money. Maybe fix them next week matter.
Which item?
28th September,
Item 90.
19,
19.
19, 19. hearing.
Yes.
Matter is urgent, my lord. Other side is absent today. He has informed me over phone. So maybe pick up next week, my lord.
You want it on
28, 9,
28.
20 September, hearing date.
All right, 28.
Operation.
Item 19 on 28 at the request of Mr.
MK Sharma Lord.
M.K. Sharma.
NK Lord.
N.K. Sharma on behalf of Mr.
HK Ras.
H.K. Das.
Corresponding,
Mr.
but 2, 3 and
K.
4.
Sharma appears for the petitioner. Yes.
Operation.
Yes, Mr. Bhatti.
My lord, this matter relates to the dismissal of the petitioner.
Hmm.
My lord, in this particular case, the petitioner was appointed to the post of the constable on 22/7/2006. And I continued in job. Later on, my lord, I obtained the leave of 1 month from 10/1/2019 to 9/2/2019 for medical treatment of my mother who suffered from liver cancer at the relevant time. My lord, due to that reason, I could not join the duty after expiry of my leave, and certain notices had been issued to me, but I did not issue the notices, and I was far away my home, either to Bombay or to Banaras. And now your lordship will see the impugned order at page 26, my.
Yes.
This is the impugned order, my lord. May I read it, my lord?
Yes.
Whereas such and such, such and such, such and such, whereas such and such district Kamrup is overstaying after expiry sanction leave with effect from 10/2/19 without prior permission of
SSB
the
rules
competent
21,
authority.
Act and rules. Yes.
authority. And whereas communications directing you to assume your duties were issued at your home address, while memo number such and such and subsequent reminder letter such and such, letter such and such, but you failed to assume your duty. Next one, and whereas a court of inquiry was ordered by order number such and such, after expiry of 30 days, your absence without leave, as per provisions contained under section 74(1) of SSB Act 2007. And whereas on receipt of COI report, I they understand after satisfied with the opinion of COI, made a report thereunder justifying your absence without leave. An inventory of government property in your possession, copy of the court inquiry is in court. My lord, that copy was not supplied to me. And whereas the abstention, so my lord, these two notices have been issued. The last notice your lordship will see, last one, and
Yes.
whereas a so-called notice, last paragraph. So was served upon you by this office number such and such with the direction to resume your duties within 15 days of the notice, as such and such telling which you shall be dismissed from service without any prior intimation. But you fail to resume your duties till date. These are the grounds, my lord. Now, my lord, first of all, at the initial stage, two notices had been issued to me, my lord. 1/3/2019 and 7/3/2019. And subsequently only this notice was issued by me, the last one. My lord, these notices, I have clarified where I was during that particular period. Your lordship will come to page 39. That is my appeal.
Page.
Sorry, my lord. Page 28, my memo of appeal, my
Yes.
28, my lord. That I have mentioned all these things, these facts I have narrated, my lord. May I read it, my lord? There
Yes.
are two. There, sir, I, the applicant on such and such, had gone home on earned leave for 1 month for treatment of my mother who is suffering from cancer. My mother is still under treatment since 26/8/2019 after admission in Homi Baba Cancer Hospital, Banarsi, which is under the control of Tata Memorial Center. The copies thereof are enclosed at page number 34. That's why before my visit at home, my mother was already admitted by my elder sister to such and such Banarsi, where the treatment is started. After my reaching home, when condition became very critical, she was admitted ICU for treatment from 14/1/2000 such and such. The copy thereof are enclosed as such and such. That's why after discharge from such and such, she was again forward on 8/2/2009 for review by the
You are unauthorizedly absent for how many days? How many months?
for my lord. I did not join.
You never
After-
joined.
I did not join, and ultimately I was dismissed.
So what
My
is wrong?
lord-
What is wrong about this order?
Yes, my lord. What I am saying that so far para 5 is very important so far this appeal is concerned. That I applicant along with my elder sister took my mother to TMS Bombay where she was under continuous treatment from 8/2/2019 to 5/4/2019. My lord, during this period, the notices had been issued to me, madam. And accordingly, I was away to Bombay, and that's why I could not give the reply. And due to the ill health of my mother, she was suffering from the liver cancer, my lord. I did not.
You are not an illiterate person,
I am not illiterate, no doubt.
but at least you could have written an application saying that this was the
Yes,
situation.
sir. The application subsequently, I filed the application, and they say that this application is not issued by us. That is a different, even though, my lord, during that particular period, I was absent in treatment of my mother. My lord, whether on such ground, whether the termination, my termination can be justified, my lord.
Of course, it can be justified. You are
I-
unauthorizedly
I'm
absent.
showing, my lord,
Yes.
whether according to the law, whether this can be justified. And this particular purpose, I'm first of all, I'm taking to your lordship to 21, section 21.
Section
of-
21.
Yeah, Shastra Sima Sevaka.
Yes.
Section 21. Absence without leave. Have you got it, my lord?
Yes.
Any person subject to this act who commits any of the following offences, namely absent himself without leave, it is not the case, my lord. Without sufficient cause, overstays leave granted to him. I fall squarely under P, my lord.
Hmm.
If I overstay without any sufficient cause, my lord, only in that case I can be terminated under Section 21.
That is exactly what happened. You were granted leave, you went and you
Yes.
overstayed
Yes,
and you did not join back.
join back due to sufficient.
Whatever it is, but no leave was granted for that period.
No, leave was not granted.
Ah.
That's why, my lord, without sufficient force, overstayed,
Hmm.
leave granted to him. I overstayed without the leave. If there is no sufficient
Hmm.
reason or materials, my lord, in that case I can be terminated. If I can show that there were sufficient reasons that why I stayed, overstayed, in that particular, that matter has to be considered.
Whether this falls under sufficient reason, on what basis are you submitting?
Because my mother was suffering from, pardon,
No. What would be sufficient cause? What will be sufficient cause
sufficient
for the purposes of Section 21?
21, because why I overstayed. That is the illness of my mother. I was busy in treatment of my mother. There was none else me. And that was the reason. And subsequently in the appeal memo, I narrated all the things by lord.
Yes.
Because there was none. So I have challenged the validity of this order. My lord, since the appeal is provided,
Hmm.
I filed the appeal. And your lordship will see the appeal memo at page 28. This is my appeal. Along with it, your lordship,
Yes.
28. Along
28.
with it,
Yes, yes.
I supplied all the documents, medical documents of my mother.
Yes.
All the documents relating to my illness of my mother, my lord, who
Hmm.
subsequently also died, my lord. Now, this how the appeal has been decided. My lord, the appeal has been decided without giving me an opportunity of being heard, first of all. And secondly, without considering the grounds which I have taken.
Yes.
Without considering the grounds which I have taken in my appeal memo of appeal, why I could not attend the office, or why I did not come back to join my duty on expiry of the period of the leave. So I have narrated, I have annexed all the documents. Now your lordship will see the appellate order which your lordship will find
Yes.
at page 39. That
Yes.
whereas, may I read it? Whereas an appeal that is such and was submitted by such and such, and issued by this office from such and such, wherein he appealed against the order of dismissal from service issued by the commandant against him by such and such, there is a request for reinstatement in service. And whereas on meticulous examination and analysis through service records of the individual concerned, and all relevant documents pertaining to case provided by the commandant such and such, the following revelations were made. That the appellant thus joined Rangya, and after posting various assemblies and such, Kaziranga on transfer from such and such. And whereas number such proceeded for availing sanction 31 days only, with effect from such and with permission to avail subject on such and such on ground whose mother treatment failed to resume his duty after expiry of leave without any prior intimation or permission from the competent authority. Further, he was marked as absent from leave with effect from such and such, has issued two joining notices on such and such as a home address with direction to resume his duty immediately memorandum such and such. But he neither resumed duty nor submitted any reasons or justification intimation about his overstay from leave and continued to overstay at home. And whereas after continuance is overstay from leave for more than 30 days, commandant such and under the president such and such inquired into the matter by such and such there is a further after completion of court of inquiry. My lord, so far the court of inquiry is concerned. During the proceeding of the court of inquiry, I was not sent any kind of notice, and it was conducted in my deck and was submitted to the commandant such of further necessary action. And whereas on the basis of court of inquiry report, the commandant such and such, under accordingly the apprehension roll was sent to concerned police authority, that is the Supreme Police District, and authorized by commandant such and such, with request to apprehend the said, and the same was informed to individual concerned through official letter with direction regime duty or base termination of the as per rule. No reply came forth from the police authority, nor did individual surrender himself or reported for duty. As such and such was again sent to police authority, this copy to individual by commandant number such and such. And where the appellant was declared the tester from for a deserter such and such under and whereas as per the instructions issued by higher headquarters and laid down rules, the commandant will be such and such thereby directing as such and such to resume his duty within 15 days of issue of test record notice. telling me he could be dismissed from service. Thereafter, such and another proper notice giving him last opportunity to resume his duty within 15 days. from
Yes, yes, okay. Then
So this all
no notice.
here without the court of inquiry was conducted in my case. So my lord, since I have taken your lordship, there must be.
But you are not available, you're not available in the premises at the camp.
Yes, because I could not.
So then,
No, on that particular day, because the date was not given to me. When my appeal is going to be heard and disposed of. No date was given to me. Had it been given, I would have been purged.
did you send any communication to the authority to say that?
Pardon, my lord?
Did you send any communication to the authority that you had to overstay your leave because of illness of your mother?
Yes. That those grounds previously I sent one letter. That your lordship will find at page 47, my lord.
47.
40. Sorry, ma'am.
This is an appeal.
Yes. Yes, my lord. G, page 36.
Page
36. This was sent on 12/7/2019. And in this one, I have narrated the entire thing, what I did, my lord. May I read it, my para 2? That the applicant on such and such, gone for on leave for 1 month, and during leave, I took my mother, who is suffering from cancer, to Banaras Homi Baba Cancer Hospital for checkup, and thereafter the applicant had to take his mother to Tata Memorial Hospital for treatment, and my mother is still there for treatment. Sir, the applicant informed in the month of August to the control room and reached the Salvador telephone and tried to send the check, which was refused by the control room due to the fact that no check for leave of any person would be entertained as per order of the commandant. That the applicant was given notice by the driver, but since he was physically and mentally stressed due to cancer, his mother, he could not reply to the notice of the department. So, my lord, the sufficient reason.
What order was passed here? Any order passed?
Here. After this, my lord, dismissal termination order was upon this petition, no order was passed. Dismissal order was they have denied that upon this application, no order has been passed. It was not considered at all, and simply so-called notice was issued.
Yes.
Now, my lord, I am taking to your lordship because now your lordship has seen both the orders, my lord. Impugn order passed by the first authority and the appellate authority, my lord. There is nothing on the face of the order that there was no sufficient reason, my lord, assigned by me why I did not attend. That is it. First, it may not be there because they had no information about it regarding the my absence from home to other places. But in appeal, it was before the appellate authority. They did not give me any opportunity. I annexed all the documents. And in spite of it, that the appellate authority did not come to the conclusion that these grounds which I have given in the appeal are not sufficient to reinstate me, my lord. In support of this contention, my lord, I beg to refer the judgment of the Honorable Supreme Court 2012 CICT page 173, my lord. 178, my lord. Regarding the misconduct, my lord.
Party name?
Party name, my lord, Krusuna Kant B. Parmar versus
Okay.
Union of India.
Willful,
Yes,
willful absence.
yes.
What else is this if not willful? You chose to be absent because your
No,
mother
not only
was.
that one. Your lordship may come to para 18, 19, and 20, my lord.
Yes.
18.
You're referring to para 22.
22. First of all, my lord,
You are relying on this for para 22.
18, my lord. First of all, 18, my lord.
18.
18, 19, 20, and later on 22. Absence from duty without any application or prior permission may amount to unauthorized absence. But it does not always mean willful. There may be different eventualities due to which an employee may absent from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such cases, the employee cannot be held guilty of failure of devotion to duty and behavior unbecoming of a government servant. In a departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove the absence is willful. In absence of such finding, the absence will not amount to misconduct. My lord, so far this case is concerned, my lord, I was not given any opportunity to appear before the court of inquiry. No notice had ever been issued to me. Otherwise, I could have attended. I could have produced the document. That was not done. Next one, in the present case, the inquiry officer of IPC, that is not relevant, my lord. Now 22, my lord. In the present case, the disciplinary authority failed to prove that the absence from duty was willful. No such finding has been given by the inquiring officer or the appellate authority, though the appellate had taken a special defense that he was prevented from attending duty. So, my lord, this is my case is entirely covered by this judgment, my lord. Because since and in appeal, the appellate order, there is nothing that I was absent from my duty without any sufficient reason or cause, my lord. So, my lord, in this particular case, your lordship will see the first at all, and now the appeal, during the hearing of the appeal. I filed the appeal. No opportunity was given to me of hearing, my lord, and I was not called upon, my lord.
Yes.
So that on the appeal, so far the appeal provision is concerned, my lord, your lordship will see order 29, rule 29. May I read?
Yes.
A person subject to this act, other than the officer who has been dismissed, removed or compulsorily retired from service, shall have the right to put in an appeal against the termination of service to any of the authorities higher than the one who has passed the termination order within 19 days of the termination of service. Now, in case of officer, I am not related to because I am not the officer, my lord. Where the appellate office says the order of dismissal, removal, retirement, this officer's order shall pass the holders as may be necessary for a period of time.
It doesn't talk about personal hearing.
Eh?
There's no mandate of personal hearing.
It does not make sense. But your lordship is well aware so far as the Honorable Supreme Court is concerned. When any order is passed against me,
No, but this is a statute. The rules
it's
do not
statute,
specify.
But even though it has to be there. It is the inbuilt procedure of giving the opportunity. Without giving me the opportunity, if the appeal is disposed of, merely for that reason, my lord. And in support of that one, my lord, I am ready to produce the judgments of the Honorable Supreme Court. And this is not today. I have not brought any judgment, my lord. Let it be come day after tomorrow. I will produce.
Yeah, why did you
That-
begin your arguments if you're not ready?
No, because simply for the reason, my lord, the statute does not provide for the opportunity of hearing.
Yes.
It where the order passed against me adversely affects me, my lord. In that case, I must be given an opportunity of being heard.
You produce the
Yes,
citation on the basis of which you're making this
my
submission.
lord, for that one, may I request that let it come day after tomorrow, I will produce it.
No, it is convenient for you day after tomorrow, but day after tomorrow, there are other matters fixed.
Any other date as may be convenient to this honorable court, my lord. Huh? All right. Any other day, my lord, as may be convenient to this honorable court, my lord. Let it be kept as the part of my lord. And any other day, my lord, as may be convenient to this honorable.
No part heard. Depends. Yes.
Lordship, there is no provision of personal hearing in appeal, Lordship, up to other.
Parmar. What do you have to say?
He had not completed his arguments or.
No, his arguments is only with regard to
Yes,
appeal.
Lordship.
We'll
Yes.
deal
Other
with appeal.
Lordship, we have given every opportunity. I have annexed all documents.
No. This willful absence. This judgment of the apex
Lordship,
court.
it's not a case that we have denied him his leave or we have not granted. He can sought for his leave.
Have you gone through the judgment?
Yes, Lord.
So this develops a concept of willful absence.
Lord.
So whether that willful absence was dealt with by the departmental authority while coming to a conclusion that his absence was willful.
Lordship, to prove that, Lordship, we had sent every letter. We have even given paper publication.
Whether it was done by the appellate authority.
Appellate authority, not Lordship.
Then.
But appellate authority had discussed other points that it's not that without going through the records, they have rejected it. The appellate order is also a long order, Lordship. And
yes, we close it.
My lord, I would produce this judgment.
All right.
Let it be kept as a part.
No part heard. Matter be listed again on 20th.
Lordship, in that case, let it be after vacation. He had taken 3 days. He starts, then he was asking for time, Lordship. Now only to let it come up on 16 November, Lordship.
This is the first.
No, not.
We'll see whatever courtmaster gives.
My lord, let it be kept part.
No part heard. Why part heard?
So that it can be heard within 10 days.
It can be heard any day. There is no concept of part heard now. Whichever bench takes up, will take up the hearing. If it comes before this bench, we'll take it up. If it doesn't, it doesn't. Give a date. No, 7th is too far. Can we not attempt on 12th October?
October, Lordship, I have some difficulty in last week. That is why I'm praying that
Would not be in Guwahati.
he will
You
not
will
be in
not
Guwahati.
be in Guwahati. Wonderful. All right, then let it go to November. Yes, November.
Obliged.
May it please the last.
Yes.
There are two review petitions and one writ petition matter. May I request your lordships to take the review petition 5721 first.
Review petition. Yes.
Now, what had happened, my lord, an advertisement was issued on 30/12/2018. And lord, if your lordship kindly comes to page 21 is the advertisement. And the relevant
21.
source is at 35.
Yes, advertisement, yes.
Please come to page 35, madam.
35. Yes.
Towards bottom for grade 4 post. The selection procedure to be followed is as per the existing service rule of the department concerned. Then my lord will kindly come to page 37.
Yes.
Roman 14. The provisions of para 3, 4, 7 and 12 of the guideline for conducting written examination person with disabilities issued by the Minister of Social Justice, Department, etc. will be followed. My lord, actually the advertisement includes both grade 3 and grade 4, but we are concerned with the grade 4 matter. Now these are all posts meant for person with disability. Now, if your lordship will kindly come to page 52. Now, this is the minutes of the meeting, my lord, held with the representative of various associations of person with disabilities regarding filling up backlog in grade 4 posts in various departments. My lord, the original recital is there. If your lordships will kindly come to page 53. Dr. Biswajit Sharma, Director, CDC, Joint Register Administration, Guwahati University, heard all the association and informed.
I may not be able to take up the matter.
My lord,
Is this order under
Biswajit Sharma, my lord.
sort of? I may not be able to take up the matter. If
Yeah, directly. Because now it is being, selection has been given to Biswajit Sharma. Biswajit Sharma is no longer there, I think, my lord. I think,
no, but if you want to,
no, I don't think he has got any personal thing in the matter. This selection was outsourced to my lord Assam Police Recruitment Board. My lord, the
no, all
issue
I'm saying is that in case we have to say or comment on this order, then at that point in time to say I may not be able to do it may not be proper.
Okay.
So if you
But my lord, our challenge is on a different perspective. What we are trying to say is, my lord, now this selection, the selection, my lord, what had happened, there were 863 posts for grade 3 and grade 4. And all these posts were meant for, my lord, person with disabilities. Now, Social Welfare Department decided to outsource the, my lord, selection process to the state level police recruitment board. And Assam, that.
No, why were you referring to this order?
No, those are only preliminary things, my lord, just to lay the foundation, the factual foundation of the case.
If you are not putting this, then
No, not at
there's
all.
no bar. But
No.
in the event after we
No, my
proceed
lord.
with the hearing and we find that we are required to
I think I'm
comment
sure,
something.
my lord, Lordship will not have to fall back upon that because I'm on a very small point, my lord.
Yes.
Now, what had happened? The Assam State Police Recruitment Board, my lord, they went ahead with the selection process as far as grade 4 is concerned. Now, what they adopted, the procedure was, my lord, they call it digital viva. My lord, what happens in the screen, my lord, multiple options come and my lord, they are to pick the particular answer.
University conducted the selection.
No.
Then?
It was Assam State Level Police Recruitment Board.
But the selection is
Now,
for?
my lord, now after abandoning the selection,
Hmm.
they would like to say that Guwahati University should conduct the examination.
Okay.
And that is how, my lord, that Biswajit Sharma's name figured. But my lord, he is no longer there. He had no role personally, my lord. University as a whole conducted the thing. Now, my lord, what had happened? There were certain development, lordship knows, SI recruitment and all, where this Assam Police State Level Recruitment Board was involved. Therefore, it was decided, my lord, by the authority to cancel the digital viva and to hand over the selection to Guwahati University and to make the selection based on internet. Now, my lord, the decision to have this digital viva was taken by the state cabinet. And lordship knows, Government of India as well as state government has come up with a policy decision that for recruitment to grade 4 posts, interview will not be the medium. That is the avowed objective of both central government and state government.
Yes.
Now, my lord, the learned single judge did not appreciate this point. Now, if your lordship kindly comes to the impugned judgment at page 106.
Why did you not file an appeal?
No, because, my lord, this is an error which is apparent on the face of the record, my lord.
Okay.
If your lordship will kindly come to page 105.
105.
Yes, para 5. Mr. D. Nath, learned government advocate appearing for the respondent submitted. Nowhere in the advertisement issued by the state level police recruitment board, mention was made that recruitment process in grade 4 would be through digital viva. But digital viva test was adopted by consortium outsourced by the state level police recruitment board. Now the whole process has been cancelled. The nodal agency and the Guwahati University, who had been entrusted by the government to conduct the examination, is free to choose the method through which recruitment process is to be conducted in terms of the conditions mentioned in the advertisement. Then my lord will kindly come to page 108. Now this is where, my lord, the error has crept in, para 9. It appears from the record that digital viva so far conducted for recruitment to the post of grade 4 has been cancelled. But before doing so, the association representing different categories of physically challenged people in Assam were taken into confidence in the meeting held in the chamber of Minister's Social Welfare Department. Besides, cancel was necessitated due to hue and cry raised by the people against the manner in which examination was conducted. As such, this court is of the view that the examination process which has been already cancelled under such circumstances cannot be carried over, that too when the recruitment process has been taken over by different body other than the one which conducted earlier. Thus, I find no merit in the first prayer of the petitioner. On the second prayer to hold the recruitment process to digital viva, after careful perusal of the advertisement, I find no mention having been made about it, or even indicating that recruitment process to the post of grade 4 should be through that method. Therefore, there has not been any change in the rules of the game. It was adopted by consortium outsourced by the state level police recruitment board for their own convenience, and not as a chosen or described by the respondent. Therefore, petitioners who are candidates for grade 4 post would not have the right to compel respondents to continue with that platform. My humble submission is, my lord, the decision to make the selection by digital Viva was taken by the state cabinet, my lord. This aspect was not noticed by the learned Singh and judge. My lord, advertisement did not, mention the method. But if the method is prescribed, that prescribed method has to be followed. Now, digital Viva, my lord, there is objectivity. Otherwise, my lord, lordship sees, if 100% there cannot be interview, my lord, 100%. If a lordship goes by the different judgment.
Come back to para 10 again.
Yes, my lord.
Para 10.
On the second prayer to hold the recruitment process to digital Viva interview, after careful peruse of the advertisement, I find no mention having been made about it or even indicating that recruitment process to the post of great purpose should be through that method. Therefore, there has not been any change in the rules of the game. It was adopted by the consortium outsourced by the state level police recruitment board for their own convenience and not as a chosen or prescribed by the respondent. Therefore, the petitioners who are candidate for the grade 4 post would not have the right to compel respondents to continue that. It's not a question of we trying to compel anybody, my lord. It is the cabinet who has taken the call. Let my lord, state government produce the records, my lord. This cabinet decision is dated 9/10/2018.
And then after cabinet, what happened? There was another change.
No, my lord, person to the cabinet, original, when
It
it
went
was,
for digital
when
Viva.
so long it was dealt with by the Assam Police Recruitment Board, they have done it through digital Viva, and we have given, my lord. More than half of it was completed.
Then why was it changed? On what basis?
My lord, without anything, my lord, because that police level recruitment board was also involved in the recruitment of SI and all those, my lord.
Which
So at
came
that
under
point
a
of
cloud.
time, there was some adverse publicity. So therefore, my lord, government has taken this decision. But my lord, interview by which now Guwahati University is doing, that cannot be done. If a lordship will kindly come to page number 110, my lord.
Yes.
Now, Guwahati University has done it through, my lord, interview. 13th of April 2017, discontinuation of interview for junior level post in Government of India, a recommendation of the Committee of Secretaries. The undersigned is directed to refer to department's OM details so and so. By these recommendations of the Committee of Secretaries for discontinuation of interview for junior level post in Government of India was conveyed to all central government ministries departments. Now clarifications have been sought for by different department organizations whether decision of continuation of interview is applicable to direct recruit only or it's applicable to other modes of recruitment also. It is clarified that decision of discontinuation of interview in junior level posts in government is applicable to recruitment to all posts up to Group B, irrespective of mode of appointment, promotion, deputation, direct recruit. Similar OM is issued by the state government at next page, my.
This is prior.
Prior. Kindly see at page 111. This is even the 25th of May 2016. I am directed to say that Honorable Prime Minister.
Now,
of
what is the university trying to do? Interview.
Interview.
Yes.
So, my lord, my humble submission is we
But was this the grounds urged before the learned
Yes,
the coordinate bench?
that's why the Lani Singh has dealt with it, my lord, at para 10 and 9 and 10.
No, if you see that court had returned the finding that there was no change of game.
Oh, my lord, I must be fair, I was not there. I'm told by my learned friend, my lord, this OM was not placed before the Lani Singh.
Yes,
be
what do you
fair.
say? Government respondents?
My lord, in this review petition, social welfare is yet to file their reply.
Huh?
Social welfare department, my lord.
What reply? This is a review. Is there an error or not? That's all.
My lord, if you go by the advertisement, there was no indication that.
No. This 111.
100.
Is it in force?
My lord, that is what. These were not part of this writ petition, my lord. So we should not answer.
This is by personal department.
Anybody, but these were not part of the writ petition, my lord.
Correct, but we are asking you whether it is in force.
That is why, my lord, we have to file a reply to this.
Oh, you give us the instruction whether it is in force on that point in time, that's all. What further affidavit you are required to file? You just have to tell us that it is in force. So if it is in force, no interview for junior level.
Up to group B.
Yes, Mr. Fukon? Anything to submit?
I only point out page 63 of the writ, the press release,
63.
63.
Yes.
The state level police recruitment board has been informed by the authorities, WPC 4017. Page 63 and Annexure 10.
Yes.
The state level police recruitment board has been informed by the authorities investigating the criminal cases related to leakage of question paper of the SIUB examination that during the course of the investigation, the name of some individuals connected to the consortium conducting the examination have come to adverse notice. Based on the above information, the SLPRB has decided to immediately disengage the consortium from all ongoing processes of various recruitment examinations. The two ongoing examinations, namely physical standard test, physical efficiency test for ABUB Constable of Assam Police and digital Viva interview for the special recruitment drive for PWD would be paused immediately with effect from 10/10/2020. Press dates will be intimated as soon as possible. It's in 2020. In 21, the entire exercise have been transferred to the Guwahati University Authority. They have conducted the examination, and after that, result has been declared.
No, examination or interview?
Interview.
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 So if this documented page 101 of the review petition is in force, then you could not have conducted interview.
It is as per direction of the state government. We are just conducting agency.
Mr. Dhar,
Result declared and appointment has.
Mr. Fukon has not come to your rescue. You will have to give us instructions about 111. Whether it is in force or it was amended subsequently, what has happened?
One other thing I may be allowed to point out. Some cases are pending regarding the second phase of examination. About 25-30 cases.
Second phase means?
That Guwahati University conducted the interview.
So what is
No,
pending?
my lord, the position is like this, my lord. There were 513 grade 4 posts. Pursuant to the interview conducted by Guwahati University, 361 has been filled up and 152 are still lying.
So these 361, is there any challenge to that? But
Those are under challenge.
in the event we come to a finding that yes, this OM stands and the matter needs to be heard, then those interviews which were conducted, they will be unsettled again.
So maybe Lordship will tag, can tag with those matters, my lord. Lordship can call for the numbers that are there. If my learned friend gives, my lord, along with
I
this.
will give the list. One case is 1002/2023, Mosmi Bora. Regarding the second phase of interview. conducted.
When is that matter fixed?
Lord, it was not fixed.
There will be a fix the date.
1002/2020. Mosmi Bora.
All right, you get the instruction updated
Yes.
meanwhile. Find out whether this,
My lord, only not this, this social welfare department, they have to file a response to this, my lord.
we are hearing a review, whether it requires review or not.
My lord.
Whether there is an error apparent or not.
Yes.
That's all. What is social welfare department got to do by filing an affidavit? This is by personal department.
Personally,
Whether,
my lord, this is from personal department. This is not an OM, my lord. This is a direct.
no,
It's a
whatever.
communication to all the departments to my
That's-
lord. If I go to the last paragraph, if I understand, my
Hmm.
lord, you were therefore requested to examine the matter in respect of all establishment under your administrative control and make necessary amendments to the respective service rules, executive instruction whenever required to discontinue the process of interview for recruitment of grade 3 and grade 4 posts. So, my lord, basically, this was a communication made to the all the head of the departments by this. So
By-
thereafter,
by the personal department.
personal department,
Now, all communications, OMs relating to service conditions are ordinarily issued by the personal department.
personal department, my lord,
So you have to find out pursuant to this whether,
whether it was carried out.
no, not carried out, whether these instructions still sustains, is continued, or whether there's a change in the policy that you can carry on with the interview. That is all we want to know.
My lord, I'll find out.
Whether they have carried out or not, we'll find out subsequently. But whether the 2016 communication for discontinuation of interview,
When the Guwahati University made the selection.
liberty apparently has been granted to Guwahati University, no doubt. But if it is discontinued by the state, then perhaps you may not like to proceed with interviews.
No, that Mosumi Bora's case, it has been fixed after 2 weeks on 28.
28/8.
So we'll fix it together.
Together.
Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. N. K. Kolita and Mr. R. Dhor, Learned Government Advocate, and Mr. P. J. Fukon for Guwahati University. This review petition has been filed seeking review of the order dated 3/3/2021 passed in WPC 1049 of 2021. The primary ground seeking review is that the Government of India by OM dated 13 April 2017 and the Government of Assam by communication as conveyed by the Department of Personnel, Government of Assam, VID, communication dated 25th of May 2016, has discontinued the process of interview for recruitment of grade 3 and grade 4 posts. Stop. Mr. K. N. Chaudhary, Learned Senior Counsel, submits that the review petitioners are persons with disability who responded to the advertisement dated 30th of December 2018, which was a recruitment for different posts of grade 3 and grade 4 reserved for persons with disability of different departments under the Government of Assam. Stop. The process of recruitment was proceeded with by the Police Housing Board,
No, my lord, Assam State Police Recruitment Board.
Assam State Police Recruitment Board initially, and the selection process adopted was by way of digital interview,
Digital Viva.
digital viva. Stop. However, subsequently, the concern, what is that? Assam Police?
Assam State Police Recruitment Board.
Assam State Police Recruitment Board decided to abandon the process of selection, and subsequently the Guwahati University came to be reposed with the responsibility of conducting the said selection. Stop. It is the grievance of the petitioner that by order dated so and so, passed in WPC so and so, the coordinate bench, the learned single judge, had rejected their contentions. However, the office memorandums dated 13th April 2017 and 25th May 2016, issued by the central government and the state government respectively, were not placed before the learned single judge and therefore not taken into consideration. Stop. If these communications and office memorandums are taken into consideration, then the order dated so and so, passed in WPC so and so, would call for a review, in as much as on a date when the Guwahati University conducted the interview, the same was barred by the office memorandum and the communication dated so and so. Stop. Para Mr. Hor, learned government advocate, submits that you would obtain instructions with regard to the status of the office memorandums and the communications issued by the government of Assam. Mr. Fukon also makes similar prayer. He further submits that a series of writ petitions pertaining to the same selection have also been filed and are pending before this court. And he submits that one of the writ petitions, being WPC number 1002 of 2023, is been listed on 28 9.
Earlier.
20, huh?
On 28 August, order has been passed to come up after
2 weeks.
Has been directed to be listed after 2 weeks. And accordingly, let these review petitions, number so and so, and 2 review petitions,
2 review petition, 1 writ petition.
along with WPC number so and so, be listed along with WPC so and so. What is it?
1002.
1002 of 2023, and other connected writ petitions. That's all.
My lord. Deep left.
May I please?
Yes.
Matter relates to your lordship. The petitioner has challenged your lordship. His removal from service, your lordship, after a disciplinary proceeding, your lordship.
Hmm.
The petitioner in the meantime has retired from service.
What was the order?
Order, your lordship will get it at your lordship.
There is no interim in the meantime.
No interim, your lordship, disciplinary proceeding termination was done, your lordship. Thereafter, we filed appeal, and after appeal, your lordship. we came back.
Yes. What is the impugned order? Where is the
Order is at page 34, your lordship.
34?
Lordship.
Yes.
Page 43 is the operative part. Last paragraph.
Yes.
Now therefore, the undersigned being the disciplinary authority in exercise of power conferred by regulation 56, appendix 2, read with regulation 59(4) and regulation 54(8) of FCI regulation 1970, Janto Mohan Sinha did and stage in charge, state number Ramnagar under Pilsor is hereby removed from the service of the corporation with immediate effect and with further direction for forfeiture of his gratuity and the suspension period of the Janto Mohan Sinha, so and so is stated as there is none to meet the ends of justice.
Yes.
Now, your lordship, the memorandum of charge is at page 20.
Yes.
May I read, your lordship?
No, tell us in a nutshell what is
Your
it?
lordship, the case is this, your lordship, that there was a physical verification of the said, your lordship, in which he was said inside, your lordship. And there are, your lordship, some after physical verifications, they found that around 4,000 and odd, your lordship, gunny bags are not valid, your lordship. And this is precisely the
Missing.
lordship.
They
No,
were
missing or what they have not said, your lordship. that they have not found it, your lordship, not tallied with the
Register.
local register, your lordship. Now, on the basis of that, your lordship, he was
You were the shed in charge.
said in charge, your lordship. I was the said in charge, and of that particular sort against 3944 packets of rice raw grade A was found short against 20 stacks. And then a district committee, office committee was formed. They also found, your lordship, shortage of 4077 bags. And it comes around, total loss comes around, your lordship, rupees 44,72,694 per, as per their assessment, your lordship. And on the basis of that, your lordship, they have issued the memorandum of charge against me, your lordship.
Hmm. Yeah, what was the inquiry
And
finding?
your lordship, inquiry conducted, and your lordship will find, your lordship, in the memorandum of charges, your lordship, there is no allegation of misappropriation, etc., your lordship, or even malapide against me, your lordship. They have, your lordship, such this
Where is the allegation of here?
lordship will get it at page 24, statement of your lordship,
24.
lordship.
Yes.
There are two charges, your lordship. Says Jayanta Mohan Sinha, so and so, said number 2, acted in a manner unbecoming of a corporation employee in as much as that he failed to maintain absolute integrity, devotion to duties, honestly and faithfully, and to safeguard the interest of corporation by committing serious irregularities. A regional office team, after peripheral counting of stocks at said number 2 on declaration of stocks as on 23/7/2010, submitted by the said in charge, detected 3944 packets of rice grade A salt against 20 stacks. The counting sheet was duly signed by Sri Jayanta Mohan Sinha, the said in charge, said number 2. A district office committee from FCI district office Silchar supervised 100% delivery operation movement of rice stocks during the month of September 2010, detected shortage of 4,770 bags, 2021.1010 quintals in respect of rice grade SA2. The total loss comes to so and so. On verification of record, it reveals that Jayanta Mohan Sinha, AG2D, taken proper care, had care, he could have saved the property of the corporation, and the corporation would not have sustained such huge loss to the tune of so and so for shortage of quintal of rice grade A. By the above act, Sri Jayanta Mohan Sharma, said in charge, said to FSD Ramnagar, failed to maintain absolute integrity.
Where is your reply? Where is your reply?
My reply is, your lordship, I denied it, your lordship. My reply, your lordship, will get it at your lordship. It's a short reply, then disciplinary proceeding starts. Page 30.
Page 30.
I said that I have the honor to state that I deny all the charges framed against me. I want to be heard in court.
You did not ask for any documents to be.
No, I did not. Now, your lordship, thereafter, your lordship, inquiry was conducted. Your lordship, the inquiry report, initially, your lordship, when writ petition was filed, your lordship, I was not there as a counsel. The inquiry report was not annexed, your lordship. Subsequently, by an additional affidavit, I have annexed it, your lordship. That your lordship will get it at page 76. Additional affidavit.
Six.
It starts from additional affidavit from page 76. Running page, your lordship.
Yes. Where is the inquiry report?
Report, your lordship. It starts from page 78, 79. 78 is the sum. The copy I was furnished by covering letter, your lordship, dated 26/2011, and page 79 onwards, your lordship, this is the inquiry.
Yes.
আপোনালোকে গাঁঠি দিছে এডিশ্যন আপোনালোকৰ এফিডেভিট নপৰিছে May I read your lordship? Article of charge, your lordship has already gone through, your lordship. The on verification, it reveals that said in charge is Jayanta Mohan Sinha. That is,
No, you are putting the inquiry report to challenge also.
No, your lordship, not as such, your lordship. I have the ultimate, your lordship, the order of punishment, your lordship.
You are praying for
Your lordship will get my prayers at
only
page
in respect
70.
of the punishment.
Lordship. Removing the petitioner, your lordship, from service, as also the appellate order. your lordship. Removal, your lordship. On the ground that your lordship, the findings are, your lordship, essentially, your lordship, perverse. And also, your lordship, even assuming
So, findings of what?
there is no finding, that's why, your lordship.
The finding is there.
No, your lordship, that's finding, your lordship, will kindly see, your lordship.
Therefore, I was asking you whether you're putting this to challenge.
No, your lordship, that finding is perverse, that is what I am.
Finding to be perverse, you have to challenge it that it was not conducted, the evidences were not
No,
considered.
no, evidences are, your lordship, they have, your lordship, ultimately, they have considered the evidences. But the finding is not, your lordship, what emerges from the evidences, your lordship. Number one. Number two, your lordship will see, your lordship, that, your lordship, ultimately, your lordship, who is responsible for that and how that shortage occurred, your lordship. Ultimately, when inquiry was conducted, that is the purport, your lordship. It started with, your lordship, loss and the blame on me, your lordship, and it ended with that, your lordship, without, and thirdly, your lordship, even assuming for a moment, your lordship, that yes, there is, your lordship, the finding is all right, your lordship. Even then, my submission will be, your lordship, the punishment is too harsh, your lordship. Disproportionate to the, your lordship. In view, more so in view of the fact that there is no allegation of misappropriation, etc., against the petitioner. That has not come out from the inquiry, your lordship. These are the, your lordship,
Okay.
broad contours of, your lordship, my argument, your lordship. And ultimately, your lordship, it is a collective responsibility, your lordship, not alone, and that reflects from the, your lordship, the brief, your lordship, filed by the, your lordship, the presenting officer's
But
brief.
you are the in charge.
In charge, but ultimately, your lordship, they say, your lordship, presenting officer, that it is collective responsibility, your lordship. Collective, your lordship. The word very used by them in their written brief, your lordship.
Collective responsibility will include you
Yes, your lordship, but
along with others.
and
But if
those
others are not others are not proceeded against,
not proceeded against. your
but will that be a ground for you to
lordship,
be?
probably, your lordship, as per your lordship.
You are going by the criminal conspiracy theory.
No, no,
That,
your lordship,
that may not apply.
our high court judgments are there, your lordship.
Yes,
You
give
said
us.
it. I
give
have
us.
so that, your lordship. First, your lordship may kindly go through the inquiry. Your lordship may kindly come to page 81, your lordship. Rest, your lordship can speak, your lordship. That I have peruse the documents, etc., inspect the documents. The documents listed as per Annexure 3 have been inspected by the charge official of said number 2 FSD Ramnagar. Issue register with effect from 3/5/2010. The register found used from page number 1 to 82 is duly certified by the said in charge. Against all issues, no concerning officer found to have signed, and this is in violation of the procedure. Register has been exhibited and marked as Exhibit 1. The register found duly clarified by the said in charge Jayanto Mohan Sinha AG 2 and from page number 1 to 53 used. Against all the receipt of the commodities and concerning officer found to have signed the register has been marked as Exhibit 2. Ghani registered with effect from April 2007. The register found in printed form and from the page number 1 to 71 in use. The Ghani ledger with effect from 1/8/2010 of the said also verified an LF4 on 16/9/2010 against CB of 15582 on physical counting of physical verification team detected only 15,501, the shortage of 68 pieces of US gun. The register has been marked as Exhibit 3. The signature of the said in charge, Jayanto Mohan Sinha, put his signature against all the gun statement marked as a master ledger with effect from 2007. The printed ledger found to have certified by the said in charge, Jayanto Mohan Sinha of the PV team detected the shortage of 4077 bags rice. The PV team made the note of shortage detected along with their signature Exhibit 4. He said LF of the master ledger and the Exhibit 4A, Exhibit 4B are the signature of by the PV team members CAK Manager D and KKC AG2D respectively against all the receipt and issue the said interest Jayanto Mohan Singh AG2 put his signature. Are the signature of the charge official Jayanto Mohan Sinha AG2B. Then the above has been exhibited and marked as Exhibit 5, 5A, 5.2, Exhibit 5A, 5B, 5C, and VD are signatures of the PV team members. So and so, so and so, so and so, so and so, respectively, against the date-wise stock position of the said inside Jayanto Mohan Singh AG, found to have signed and his signature have been marked here as Exhibit 5A. Personal statement of the said insert of said number 2 in the personal statement addressed to GM. Some reason he denied the charge brought against him and prayed for hearing him in person. Exhibit 4 is the said statement. PV report going to submitted. The enclosure of the PV report are the declaration of stocks where rice grade 1 was 31,524 bags. Statement in regard of issue and receipt of rice, stake-wise counting by physical verification team, total 4 page and summary 1 page. The PV report as per the above enclosure clearly stated that shortage detected by the PV team. The PV report has been exhibited by the marked as Exhibit 7. The signature of the manager residence who signed the PV report marked as Exhibit 7A, Exhibit 7B is the statement.
Come to page 84 and 85.
Lordship. Presenting officer brief.
Now
Your
come to
Lordship,
the defense reply.
that before that, your Lordship, presenting officer brief, your Lordship,
All right.
received the brief from the presenting officer so and so. In his brief, considering the documentary evidence exhibited during inquiry and witness examined both in prosecution and defense, he mentioned that the charge officer Jayanto Mohan Singh AG2 is not free from the collective responsibilities of the article of charges framed against him, article of charges proved. Now defense reply. All the time in defense, the charge officer denied the article of charges. Defense witnesses, namely Harun Chandra Dev, Vikas Roy, Gaurangalal Nath, Ashok Kumar Paul, Sankar Chakraborty, Mohammad Motiur Rahman, and Ajoy Nath Bhattacharya, when examined as per request of the charge officer. In replying to the defense questionnaire, the defense witness Harun Chandra Dev stated that shortage in question may occur because of shortage received from rail and truck, storage damage. Sri Vikas Roy stated that during his duty received shortage when defects are recorded in front of the CTL full bag shortage and during rainy season, water damage found in the consignment. Witness Sri Gaurangalal Nath stated that there were damage in bottom layer of some stock with Ashish Kumar Pal did not speak anything as to how this shortage occurs. With HW man stated that he used to perform his duty for the safety and security of the FCI property, and in case of shortage detected during receipt preparation, he used to inform the state in charge. Mohiur Rahman, HW man, stated that the shortage may occur due to bottom layer damage of rice. None of the above the witnesses could have given any convincing justified reason of the huge shortage of rice grade A at the state number 2 where they performed their duties. It appears from their statement that just to defend the charge official, they stated only on presumption. During the course of the inquiry of the relevant record listed as per Annex 3, it is well evident that 4077 bags of rice grade A 2021 quintal valued at rupees 44,72,649 detected shortage. The charge officer Jayanto Mohan Singh, the said in charge of set number 2 of the material field, also accepted the shortage without dispute. Reason of such huge shortage could not be given by the said in charge, that is the charge officer. On the other hand, the witness so and so clearly stated that they conducted the peripheral counting at set number 2 of FSD Ramnagar as per order of so and so dated 19/7/2010 and detected
This is the finding,
Lordship, this is the
reasonably exhaustive finding on the basis of evidence.
Lordship will kindly see there are two aspects, Your Lordship. This, firstly, Your Lordship, we should go by the statement of the defense witness. Why this statement of the defense witness should be discarded as presumption, Your Lordship? That's number one, Your Lordship. Discarded
No,
as a, there
discarded
is
as a
possibility of, Your Lordship, there is possibility
No,
of.
no, is it, is it your case that as a shed in charge, you have no means to find out the shortage?
No, Your Lordship.
You have no control over the
No, Your
grains
Lordship
which
will
are
kindly
under the.
see, Your Lordship, if there is my case is that, Your Lordship, I will show from my reply on.
Firstly, is there a shortage or no?
Yes, that's an admitted position.
That is
I
an
have
admitted-
admitted in my.
Now, in that shortage, relates to your shed,
Said, Your
the
Lordship.
shed of which you are the in charge.
Lordship.
Now, while you are on duty, while these goods were in and out of the shed, is there a procedure prescribed under the rules or
Yes,
practice?
but Your Lordship, Your Lordship, there is nothing in the inquiry report, Your Lordship.
But once you admit that there is a shortage,
I also.
you'll have to explain
I have explained, Your Lordship, that the cumulative factors, Your Lordship, resulting in this shortage. Your
what is
Lordship.
that cumulative.
That's what, Your Lordship, defense witnesses said, Your Lordship.
What is
These
that?
are the stand from the very beginning, Your
No,
Lordship.
it doesn't explain shortage.
That is the shortage, Your Lordship. This is the reason cumulative factors at play, Your Lordship, which ultimately resulted in this shortage, Your Lordship.
No.
This is Your Lordship.
This is
my
a
stand
vague,
of-
this is a vague description.
No, Your Lordship will kindly see, Your Lordship. Ultimately, they will.
Now,
not-
see.
Lordship.
We are just trying to
No,
understand. We are
Lordship,
not-
Lordship, I understand.
See, for instance, if you turn to page 84 at the bottom,
Lordship.
in replying to so and so stated, shortage may have occurred because of shortage received from rail.
Lordship.
Now, the whole purpose of maintaining a stock register, find out what has come and what has gone out. Now, the moment you have entered into a stock register, unless you say that we have no means or there is no system to verify the actual quantity,
That, Your Lordship, I have said, Your Lordship, that, Your Lordship, when this is on transportation receipt, it's 10% is only, Your Lordship, verified, Your Lordship. Rest not, Your Lordship. That is
what
my
is the
stand,
amount of shortage?
Lordship. It is your
4,077 bags.
text, Your Lordship.
Then how can it be 10%? What is the
No,
total
no,
amount?
Your Lordship, then, Your Lordship, they will have to produce that, Your Lordship, that how much has been, Your Lordship, brought, Your Lordship, how much. It is a fact, Your Lordship, that such loss has taken place, and this is not only limited to this particular area. Everywhere, Your Lordship, in.
Oh, forget everywhere.
Lordship.
We are concerned about your shed,
Yes, Your
where
Lordship,
you are
yes.
the shed in charge.
Lordship.
You admit,
Lordship, I admit that.
You
There
admit.
is a loss, Your Lordship.
you admit.
Shortage, Your Lordship.
But did you point out that this is the amount of shortage?
No, Your Lordship,
at
I
any-
didn't have any.
No, not in this inquiry. At any time prior to the inquiry, during
No,
your
Your
course
Lordship,
of
I
your
did not,
duty.
Your Lordship. That I did not, Your Lordship, because, Your Lordship, I was not aware, Your Lordship.
Now,
because-
if it is not pointed out, and if you admit, then you are bound to explain
No,
how
Your
the shortage is
Lordship,
occurred.
Can you see, there is no procedure for that. It is the physical verification conducted from time to time, Your Lordship, through which these were found out, Your Lordship.
So these are issues you have to raise.
Lordship.
That is what I'm asking you, that is it your case that there is no procedure prescribed for finding out the shortage?
Yes, Your Lordship, so far as I am concerned, Your Lordship, the procedure, Your Lordship, is that the way, Your Lordship, physical verification has been conducted, Your Lordship, in the case, Your Lordship. That is the procedure, Your Lordship. I don't have any means to, Your Lordship, find that out, Your Lordship. Huge amount of goods come. Your
Where have you stated that?
Now, Your Lordship will kindly come to my reply, Your Lordship, to the inquiry report. Your Lordship. That is very vital for me, Your Lordship. My entire case is there, Your Lordship. That is at page 31
31,
of the writ petition, Your Lordship.
yes. You had pointed out some other reply earlier, no?
No, Your Lordship, that is, Your Lordship, the initial, after receiving the charge memo, I had to, Your Lordship, first propose notice.
Page
Now
30,
this is, Your Lordship, my
30,
Lordship,
30.
Lordship, Annexure C, Your Lordship.
30 is in response to the charge memo.
No, Your Lordship, it is in response to the inquiry report. Your Lordship. The
Okay.
procedure, Your Worship, on inquiry report, my preference is to be given, Your Worship.
In respect of the charge, reply is at 31.
That is, Your Worship, this is Your Worship on inquiry, 31.
31.
31.
And in response to your charge memo,
That is 30.
that is what I'm saying.
30.
So all
Where
these things are not explained there.
I have not explained.
Now, what have you stated regarding this?
May I read, Your Lordship?
Slightly difficult to read.
Lordship. Your Lordship. Reference to the subject cited above, the undersigned submits the following few lines for your perusal and kind consideration. At the outset, it is to state that the departmental inquiry held against me under the referred memo, and after the examination of all the witnesses called for to depose before the inquiry and on different dates, and lastly on 25/5/2011, the inquiry officer hereinafter to be referred as you did not fix any date for submission of the prosecution brief, and no date was fixed for submission of the defense brief by the charge officer. The inquiry officer also did not give the copies of the statement of the witnesses that was recorded in different dates, and ultimately the copies of the statements and the copy of the prosecution brief was received by my defense assistant only on 23/6/2011. But before I could submit my defense brief, I received the copy of the inquiry report. That is also one of the ground, Your Lordship. Report by your office letter number so and so, dated so and so to the area manager so and so. Since the procedural requirement was not followed and scope to file the defense brief before the inquiry officer was not available, I do enclose the defense brief in original herewith as an XRA for your reference and taking cognizance of the same for a fair adjudication of the case. Regarding the submission of the representation against the inquiry report, the following few lines are submitted for your perusal and kind consideration. That during my tenure at FSD Ramnagar, I was posted as state in charge of state number 2 since long, and I discharged my duty without any blemish and to the satisfaction of the depot in charge and the other district officials. Though I
Okay.
was the state in charge, I did not hold the keys of
Now,
this.
let us just quickly ask the respondents.
Sure.
We come to page number 24. Articles of charge.
Yes, sir.
You refer to the charges. What is the peripheral counting of stocks?
Peripheral means the only outer counting. 100% is all the bags will be counted. Peripheral means the outer one.
So this is just a sample
Yes,
counting.
peripheral counting from the left side and bottom.
Then come to charge number 2.
Charge number 2, district office, that is 100%.
Hmm.
Thereafter 100% by the district office.
Now, what is the process of goods coming in, going out, loss? Is there any procedure prescribed?
There has to be, it's not there here. There has to be. But I think if your lordship peruse the impugn order, it explains everything. I'll read the impugn order, punishment order.
Page number?
It's a page number.
Page number?
That is. I got the unamended one, the amended. Page 34. Page 34. That is dated 22nd of December 2011. My lord will come to after the charges in his reply. I'll read from this, my lord. No, my lord. Yes. I'll read from this. In his reply, lordship got it, my lord.
Yes.
In his reply dated 27/7, he stated that shortages number of bags packets may have to be cumulative result of years together shortage loss caused due to the fact of bottom layer damage of several stacks, and the same could be taken into account under certain unavoidable circumstances. Since a couple of periods of stacks are built on bare floor and remain in the godown for more than 2-3 months, ultimately the quantity of bottom layer
would not be collected as the same so and so. The inquiry officer simply relied on, so these are his grounds, my lord. Let me skip it. My lord, Lordship will come to, having gone through the charge sheet, reply, my Lordship got it, my lord.
Page number?
Page number for the, my lord, I am having the unamended one, my lord, 39.
39.
39. Lordship got it, my lord.
Page 39.
39, yes.
Yes. Having gone through the charge sheet, reply thereto, PV report, inquiry report, CO submissions towards IO report, the relevant depot records. From the record, the factum of shortage of detected during PV conducted by the RO team as on 23/7/2010 and 100% weighment of rice grade A stocks conducted by DO Silchar team as on so and so at shed number 2 Ramnagar Silchar reveals as under. Jayantamohan Singh AG2 depot was functioning as shed in charge in shed number 2 of FSD Ramnagar with effect from September 2004 till completion of 100% weighment. Sri Sinha has given the declaration of food grain stocks sugar gunny to the RO PV team as on 23/7/2010 opening balance as well as to the DO team Silchar on 16/9/2010. As per Stack Ledger, the rice grade A, it is observed that shortage of 3944 bags of rice grade A were detected by RO PV team as on 23/7/2010 was against stocks received during July 2010, that is from 1/7/2010 to 22/7/2010, except 50 bags of rice packets, which are found short against 2 stacks June 2010. This is not years together. Next, from the record, it is also observed that Sri Jayantamohan Singh AG2 depot had issued out all stocks received during July 2010 by showing nominal storage loss, even those stacks were where.
What is the meaning of issued out?
After issue. Issue means, I mean, after, yes, from the depot.
They have left.
Yes. Were detected for regional PV team. From act of Sri James Sinha, AG2, it is evident that he has been trying to nullify the findings of the regional PV team by manipulating the stocks, but he could not hide out the shortage detected by RO team, which is evident proved during 100% weighment. During 100% weighment, rice grade A conducted by the team of FCA RO DO Silchar on 16/9/2010, the declaration of rice stocks were also given by JM Singha AG2. The then shed in charge number 2. As per declaration, as on 16/9/2010, there was only 3 stacks, stack number so and so. As per record, all these 3 stacks were built up during August 2010. Out of these 3 stacks, 2 stacks were not found existence at all, physically. You know, these bags are kept in stacks. 2 stacks are not found physically in existence. This is, how can it escape his notice? And against stack number so and so, only 91 bags found in existence against the declaration of 1371 bags. The weight of 91 bags found 44.13 quintals. Hence, during 100% weighment, total shortage comes to 4077 bags, that is 2021.10 quintals. Another 133 bags found short during 100% weighment against the shortage of so and so detected RO PV team as per declaration given by James Singh. During 100% weighment rice grade A stock, team deputed by DORO also found 68 pieces empty gunny bags short against the declaration given by James Singh. Sri Jayantamohan Singh, in his reply dated so and so towards spot memo issued by manager PV team, RO Guwahati White dated auto, though he has put forth the reasons for occurrence of shortage 3944 bags, but it cannot be accepted because there is no evidence for long storage, 2-3 months, and large scale damage of bottom layer bags of the stacks as per depot records. If the damage of bottom layer bags are factual, then it was also his duty to collect all these bag grains, because these damaged grains are also part of the good stock, good grains received in the godown shed to misuse of any kind of corporation property without prior approval, so and so. Considering all the above factors, circumstances, and findings, observations, inquiry officer conforms to the standard of proof as required to establish guilty, so and so. Next para. Now, therefore, the undersigned being disciplinary authority in exercise of power, so and so, Sri Joyantaman Singha, the then shed in charge, shed number 2, Ramnagar, hereby removed from service corporation with immediate effect, with further direction of forfeiture of his gratuity and suspension, so and so. Period is diagnosed. Now, my lord, your lordship has seen the other case. Lordship has heard the other matter. Same depot, same his colleague. That is WP. That is pending by my lordship for judgment. WPC number 4682 up to the same inquiry officer, same time. Saifur Raja Chaudhary, the lordship heard the matter on 29/8/2023. And lordship reserved it for order. Same inquiry officer, his colleague. In that case, of course, that was an
You don't want us to reserve it for judgment prior to delivery.
No, my lord, what I say that it is the same. The modus operandi are same. One, in the other case, it was excess. Here it is shortage. Huge shortage. His explanation is that is accumulated for years together. But it was from a particular month. It is calculated, received in a month, and that shortage. And few stock stakes are found not in existence. How a depot in charge cannot report, my lord, should not report it. And your lordship, I have given your lordship the job description the other day in the other case. I just have a copy. I can give one copy to your lordship about this. And the regulation is also with your lordship. In that case, my lord, I can give the regulations, the violations, my lord. He has a depot in charge duty under the regulation to look into every transaction. That is also there, my lord. He has been charged with. I can read
So we'll deal with the other case first so that he gets an opportunity to find out what is the finding, because
my lord, what I say, my lord, that since it is apparent the loss occurred, he is a shared injured. He cannot escape his liability to be a shared injured. It is not that other persons are, my lord, are not charge sheeted.
What is the punishment is prescribed under the rules?
Lordship, that is your lordship, the rule of it. 54, regulation 54. I think it's 54.
Major penalties, your lordship. Reduction to a lower stage, the time scale of pay for a specified period with further direction to whether or not the employee of the corporation. will earn
Is
it.
removal there or not?
Yes,
It's
lordship.
there, it's
Removal
there.
from
Remove,
service,
sir.
which shall not be disqualification of future employment, but he has at the pay end of his career. your lordship.
But in other case, my lord, I considered that since there was no loss, forfeiture of gratuity ought not to be in the here there is a huge loss. That is the difference of the question.
That loss has not been quantified yet.
Loss
Is it
They have
quantified here?
Quantified.
44 lakhs, your lordship. In fact, I will, your lordship, place certain judgments, your lordship, on this, your lordship, lost, your lordship, what our high court has. ordered.
Yes.
I can
You want
give
to
your
do it
lordship
today?
Lordship,
You want to do it today? No, you said you are placing some judgments.
lordship judgments, your lordship, I will place, your lordship.
You want to place it today?
As per your lordship. if you
No,
lordship-
no. If you are you placing it today or you want some other date? That's what I'm asking you.
I have brought this judgment.
Very well, give it to us.
I can give the copies to your lordship.
Of what?
Of the judgment I given in the other cases, but I will give it to your lordship. The quantum and all.
All right. What are the judgments?
Judgments, your lordship. One is your lordship 2012 SCC online Guwahati 928. Your lordship may already go through it, your lordship.
You do one thing, you give the list. We'll take it up next week.
Sure.
We'll get the judgments and we'll
That's better.
continue with the hearing.
That's better. That's better. Okay. This will.
Yes. At least next week will be the Thursday
28 euro.
or further hearing. Enabling Mr. Pothapu, enabling the councils to rely on the judgment. They seek to place the judgment, they seek to rely upon. It's on 28th. 28th.
28. Deeply.
Yes.
Next, your Lordship. Lordship, in this case, yesterday I have received the inquiry report, Lordship. Lordship, 2 weeks time may be granted that I can file affidavit, Lordship.
MS Bora,
Lordship.
G. Bora Learned Counsel appearing for the respondents. Crave leave to file an affidavit in opposition as the instructions have been received, stated to have been received. You have taken consent of the petitioner. You have informed the petitioner.
No, Lordship, but
Okay.
junior.
However, since none appears for the petitioner, matter stands. Prayer is allowed. List after
4 weeks, Lordship.
3 weeks.
Highly obliged.
Hmm? 24? No, no.